The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, good morning, everyone. Welcome to the Fourth Circuit. We'll hear argument in Grimet versus Freeman. Mr. Dreeben, whenever you're ready.
Thank you, Judge Diaz, and may it please the court. My name is Michael Dreeben, and I represent the appellants in this case. North Carolina is one of only 9 states that has a criminal statute specifically directed at candidate activities. These states have not enforced these statutes throughout history. We are aware of only one prosecution under any of these statutes in North Carolina in 1947. This state of affairs reflects that the states have not found it necessary. 40 states have no such statute whatsoever, and the state cannot demonstrate that the experience of the states requires any such criminalization of campaign speech. As a content-based statute directed at the political process, North Carolina can only sustain the validity of its statute if it can satisfy strict scrutiny. It cannot do that. The statute is not necessary to further a compelling state interest. The interest of the states and of the United States in campaigns that are free from defamatory, derogatory, false campaigning is apparent, but the necessity of a criminal statute to enforce that is not. The state has the burden of showing through empirical evidence that such statutes are needed to serve the interest of election integrity, and it cannot do that. In fact, the statutes in operation tend to chill political speech, skew the democratic process, and interfere with the very interests that the statute purportedly is designed to serve. On top of that, the statute is under-inclusive of false statements that can impinge on election integrity, and that undermines the state's asserted interest in protecting
Mr. Dreeben, can I ask about that? So we don't always command legislatures to legislate broadly. They're allowed to experiment and legislate narrowly if they so choose. So what's the problem with having a statute like this one that targets a specific component of a problem that the legislature apparently seemed to think affected the political back and forth?
So, Judge Diaz, this statute is one-sided in the kinds of speech that it affects in the electorate. It says nothing about a candidate that chooses falsely to inflate the candidate's credentials, to pollute the electoral process with false claims against himself. And instead of the ordinary remedy in our political process of counter-speech, the statute chills the opposing candidate or those allied with the opposing candidate from countering false laudatory statements.
So if the statute included those components which you say have been omitted, would it pass constitutional muster?
Well, there are other components that are also missing from this statute that I think undermines the compelling state interest, and I would not be prepared to state categorically that any criminal libel statute directed at the political process is constitutional, because I think at the most fundamental level, the state cannot show that the remedies of counter-speech in our political process and civil defamation actions to protect reputation are inadequate. And it is the state's burden to come forward to justify a criminal remedy in an area where this country has traditionally not had criminal remedies. And dating back to the Alien and Sedition Act, which is widely regarded as unconstitutional, the traditions of our First Amendment are that counter speech and free debate in the political process are the order of the day.
Can I ask you about, so it sounds like you might not be prepared to answer this question, but the district court below seemed to think that, first of all, thought that Garrison, the Supreme Court case, remained good law, which is a much broader defamatory statute than what we have here, and but for the absence of a malice requirement in that statute, it would seem the Supreme Court, at least as of 30 years ago, would have been inclined to uphold a statute like that. So what about that kind of a statute?
At the outset, Garrison did not actually uphold the constitutionality of any statute. I understand that it can be read as saying that if the New York Times actual malice standard were incorporated into a criminal libel statute, that would be enough. But that actually is not the holding of the court, because Louisiana's statute did not involve an actual malice standard. So it's dictum. Beyond that, the statute in Louisiana was a generic statute. It was not specifically aimed at the political process. So there are different issues that are raised by a libel statute that's aimed at the political process. For example, in the one case in history that I found where the court has upheld a criminal libel statute in the Beauharnais case, Beauharnais versus Illinois, it was a group libel statute that was specifically aimed at false accusations or degradation of people based on race. And the court dropped a footnote, footnote 18, in which it specifically said, of course, if this were aimed at candidates or political parties, very different questions would be raised. Political men or political people who have thrust themselves into the public eye stand on a very different footing. And so that tracks into a very different tradition than the one that the court looked at in Garrison.
It also creates the RAV problem, right? If you're only going to criminalize political libel, now you've got an RAV problem.
That's correct. And there are subsequent developments in constitutional law, Judge Heitens, that I think reflect evolution from where Garrison is. Even within a category, if we assume that false statements made with actual malice about political candidates could be criminalized under a broader rubric of unprotected speech when it's false and made with actual malice, the court's holding in RAV versus City of St. Paul is that even within a category of unprotected speech, further distinctions based on content need to be run through strict scrutiny. And that's where I think this statute fails. If you do run the statute through strict scrutiny, the state has the burden of showing a compelling interest in narrow tailoring, and that the statute actually furthers the interest. I don't think it can make any of those showings. And if I can make one more comment about how Garrison has been left behind other Supreme Court cases, the centerpiece of Garrison's analysis was false statements made with actual malice are not subject to constitutional protection at all. And the Supreme Court repudiated that reasoning in United States versus Alvarez, where the plurality opinion specifically noted Garrison along with a litany of other cases that the government had cited that contained that broad language. And the plurality said that those statements exist, but they don't carry the day when we are confronted with a statute that actually addresses false statements. We do need to run it through First Amendment.
Didn't the court say, to be fair, that those statements don't carry the day because the context, the cases where those statements came from, dealt with categories of speech that were, for our purposes, Garrison was defamation, right? It was a category of speech that the court considered outside of the normal First Amendment approach. And so we may have a preliminary question here. Are we dealing with a defamation statute? And then if we're not, if this statute covers true speech, then we get into our normal First Amendment analysis. But I think it might be a stretch to say that the Supreme Court cast off the idea that false speech in other contexts, like in defamation, is now fair game under the First Amendment.
Well, I agree with that, Judge Rushing. And what the court's point in Alvarez was that you need falsity plus, but Garrison did not rely on that. Garrison's statement that false statements categorically fall outside the scope of the First Amendment was integral to the court's reasoning, and that did not survive Alvarez. We do get into the question, I think, as Your Honor properly raises, of whether a criminal defamation statute can survive. Surely we know that there are civil defamation statutes that survive. And those statutes, I think, at a minimum, show that a criminal defamation statute that's aimed at protecting individual reputation is neither necessary nor narrowly tailored. The state has made no effort to show that a civil damages defamation remedy is inadequate to protect reputation. And if in any context it would be adequate, it would be in the context of political candidates who have a platform in society in which they can.
Can I ask you about that? Not to move you off of this, but before you sit down, I wanted to ask about the irreparable harm piece of this. And I know, innumerable cases say that any violation of your constitutional rights, even for, a small time, is irreparable. But in this case, my understanding is you want, or your clients would want an injunction to prevent the indictment, right? To prevent the DA from bringing charges based on this advertisement until the case is done, right? This is a preliminary injunction. It would last until the district court issues a judgment.
Correct.
And I wanted to ask, how will your clients' First Amendment rights be infringed in the interim until a judgment's delivered if there's not an injunction?
So our clients are involved in the political process. They are an elected official and people who are involved in campaigning. And the allegations of the complaint include that they would be chilled in the exercise of First Amendment rights by the potential threat of criminal.
Are there campaigns currently happening?
No, there are not campaigns that are happening at this moment, but these are people who are engaged in public life. One of the.
Will there be a campaign between now and, the expected time, how long it would take for a judgment in the district court? I know we just finished an election cycle. How long till the next campaign cycle starts?
I don't know, but one of the plaintiffs in the case is a media consultant that is regularly involved in the political process, and as Your Honor knows, included an affidavit that indicated that that entity would be chilled by the threat of criminal prosecution.
They said they may have to potentially reconsider possibly
Yes,
whether they would.
I understand your
continue to do
reservations
business in
about
North
that.
Carolina.
The panel concluded that at the preliminary stage we had shown irreparable harm, but Judge Rushing, what I would emphasize at the end of the day, if you're not persuaded on irreparable harm, is we're on appeal from a preliminary injunction in which the district court said we did not have a likelihood of success in showing that the statute was facially unconstitutional. If the court reverses that determination, can leave everything else for the district court to determine about the appropriateness of injunctive relief.
You need a ruling on the constitutional issue to go back to the district court, whether
Correct.
we say there should be an injunction or not.
That's correct. The Fourth Circuit does not have to determine that issue without the benefit of a full airing in the district court. We do think that the record unequivocally shows a harm to First Amendment rights. We may disagree about whether there is irreparable harm, but the central.
Struck me as, usually in these cases you have I want to say X, today and tomorrow and next month, and unless there's an injunction, I'm going to be prevented from saying X.
Yes.
But that's not the argument here. X was said 2 years ago. Nobody wants to say it again.
Well,
but they don't want to be indicted, which the Supreme Court has told us is not irreparable harm. And there's a tension there.
I think, Judge Rushing, that may be a little bit of ignoring parts of the record in which the DNA issue is still alive in North Carolina. That's what prompted this case. It began with speech, counter-speech, and counter-speech, which is the way the First Amendment ought to operate.
But is it alive today? Is this an issue for campaigns right now?
It can be. We have an affidavit from a potential opponent of appellee who indicated that he would speak out on the DNA issue.
He would be covered by our injunction, would he? Our injunction just has to do with the parties in front of the court.
If we're focused exclusively on irreparable harm, yes. If we're focused on the question of whether there is irreparable harm because of your court and the Supreme Court's recognition that any chill of First Amendment rights is irreparable harm, then I think this goes to the public interest factor and whether—
Mr. Dreeben, can I ask you two procedural questions? My understanding is there were some interventions that happened after the district court ruled. Could you just help me understand what happened and what the current state with regard to those is?
Yes, Judge Heidens, they weren't exactly interventions. The complaint was amended to add 3 additional plaintiffs.
And who are they?
After the issuance of the presentment, and then a notice of appeal was filed with this court that amended to include all 6 plaintiffs. So
How can someone who wasn't a plaintiff at the time of the district court's order appeal from that order?
My understanding is that by amending the complaint, they became subject to the district court's order. That is not explicitly stated, I don't think, in any pleadings that are in the district court. So if the court chooses to rely on the 3 original plaintiffs as proper appellees and doesn't reach the issue of the others, then that is a matter that can be addressed on remand. But I think it's fairly evident, even if not explicitly stated, that the district court's ruling that there was not a likelihood of success equally applies to the 3 additional plaintiffs who are actually now facing the threat of prosecution in a more realistic way. So I'd like to turn at least briefly to the narrowest ground on which I think the court could conclude that there's a likelihood of success, and that's the ground that the panel relied on at the injunction pending appeal stage. This statute is very unusual. I looked this morning at the other statutes that different states have that have addressed false speech in the campaigning context. All of them are explicitly limited to false speech. This one is not. It covers derogatory speech about a candidate in a political campaign, and it has 2 alternative mental states. One of them is knowing falsity, and I will concede that that one at least strongly implies that falsity must be shown. The other one is reckless disregard for truth or falsity. That component of the mental state requirement does not imply any need to show falsity, and it provides a pathway for a prosecutor in every single case to choose the easier route. Rather than showing that there is in fact falsity in the statement that's been challenged, the prosecutor can simply allege that it is derogatory, which means disparaging. The North Carolina Supreme Court in State versus Peter Silly so held as to a statute that appears 1 section before our statute in the very same statutory series, does not imply falsity. Prosecutor can allege a derogatory statement in a campaign and say that it was made with reckless disregard for truth or falsity, and it was intended to influence the campaign. That states a violation, and anyone in North Carolina can look at the face of the statute and see that it relieves the prosecution of that burden. And under Garrison and other cases, truthful speech, particularly in a political campaign, probably in any context, cannot be subjected to a criminal penalty. And on that basis, the statute fails overbreadth analysis and is facially unconstitutional. Now,
Mr. Dreeben, you're a few minutes over your time.
sorry, Your Honor. Thank you.
I'll stop you there and you'll have some rebuttal.
Thank you.
Mr. Zatarski.
Thank you, Judge Diaz, and may it please the court. My name is Joe Zatarski, and I represent the appellee, the Office of the District Attorney in this case. The district court correctly found that this statute is a criminal defamation statute that is authorized by Garrison and is constitutional. At the outset, I'd like to stress the extraordinary nature of the relief that the plaintiffs are seeking here. They're asking this court to declare a state statute unconstitutional on its face. The law correctly disfavors these types of attacks because a state law is a reflection of the will of the legislature, that is the will of the people. And we've cited in our brief the various aspects of the law that talk about how difficult it is for somebody to make a facial challenge to a statute. I'd like first, if I may, members of the court, to talk a little bit about Garrison, because that really is central and necessary to the plaintiff's attack on the
Before you get into that, can I ask you a procedural question that I think is, I reread the district court's opinion this morning. Do you agree the district court denied a preliminary injunction based solely on lack of likelihood of success?
Yes.
Okay. So do you agree with your colleague on the other side that we wouldn't necessarily have to reach any of those other issues? In fact, given the abuse of discretion standard, maybe we shouldn't. But do you agree at least that we don't have to reach any other issues?
I believe, Your Honor, yes, because the district court's order specifically says that she was denying the motion based on the lack of likelihood of success on the merits.
Great, thank you.
Correct. With respect to Garrison, the plaintiffs basically assert the notion that Garrison doesn't mean what the district court said it means. And we would argue to you that Garrison very clearly means what the district court said it means. The district court said criminal libel statutes prohibiting false defamatory statements made with actual malice do not violate the First Amendment, relying on Garrison. And this was reaffirmed. There's been some discussion about Garrison being an older case from the 1960s. This was reaffirmed less than a month ago by the First Circuit in Freese. Mr. Dreeben beat me to the punch with submitting the supplemental authority notice. In Freese, there was a facial challenge to the New Hampshire criminal defamation statute. And Freese said Garrison controls.
Was that a broad statute, or did it apply solely?
Yes.
Well, isn't that the problem here? I mean, we've got a statute that is targeted at a specific subset of speech, the very core of the First Amendment, political speech. I mean, what does Garrison have to say about that?
Well, what Garrison says, Your Honor, is that criminal defamation statutes fall outside of the traditional categories of expression that are protected by the First Amendment. So, Freese, the First Circuit case, held there that general statute, which, by the way, does apply to political speech, the defendant in Freese, the criminal defendant, one of the things he was being prosecuted for was the criticism of public officials. And the district court case in Freese specifically talks about that.
But what about the RAV problem? Because I agree with you. The Supreme Court has said that criminal libel is not protected by the First Amendment, and let's assume that's still good law. But then RAV comes along and says you cannot, within the category of unprotected speech, distinguish based on content, because RAV involved a statute that barred intimidating speech. And we also know that threatening speech is not protected by the First Amendment. Right. But RAV says you could pass a law criminalizing all threatening speech, but you can't pass a law that criminalizes some types of threatening speech, but not the others. Why isn't that this case?
It's not, Your Honor, because of what's identified in RAV. Justice Scalia goes on in RAV to talk about the federal statutes that, for example, criminalize threats against the president. Mm-hmm. They don't criminalize threats against other members of government or other people involved in government. And RAV says that's okay because you're looking at who the subject of the speech is. Here, this statute, we're looking at the subject of the speech.
Okay, you're quite right about that. RAV doesn't say a statute that further distinguishes is categorically unconstitutional. I take your point there, and I think you're quite right. But what it says is, to the extent you want to criminalize a subset, the reason for criminalizing the subset has to relate to the reason that the speech is unprotected in the first place. And so for the presidential threat statute, we say, you know, threats against all government officials are bad, but it seems self-evidently obvious that threats against the sole executive of the United States are particularly bad. What evidence could we cite to say that criminal defamation involving politicians is uniquely bad to the point where we're going to criminalize only that type of definition? I mean, if anything, your friend on the other side says the minute you run for office, you sort of kind of accept that people are going to lie about you sometimes in a way that private citizens don't.
Well, Your Honor, I think that we have to take one step back in RAV, which is here, this is a statute that says it's criminalizing false defamatory statements, which are traditionally outside of the First Amendment.
Well,
within that,
so, I'm sorry to interrupt you, but your colleague on the other side makes the point that the statute doesn't simply criminalize false defamatory statements. In the way it's worded, it actually applies to even truthful statements.
Well, and Your Honor, we would very strongly disagree with that.
I bet you would. But the problem is that the North Carolina Supreme Court, as Mr. Dreeben pointed out, in an adjoining section of that very same statute, defined the word derogatory to mean both false statements and statements made truthfully with reckless disregard. So why shouldn't we apply that definition here?
Because the subsection in Peter-Silly, Your Honor, that the Supreme Court of North Carolina was interpreting does not have the modifier, the actual malice Sullivan modifier in that part of the statute. It does not say what this statute says in terms of knowing such report to be false or in reckless disregard of its truth or falsity. That phrase, which is in our statute, is not in the subsection that the Peter-Silly court was examining. That's why the Peter-Silly court said derogatory statements there mean truthful statements, mean false statements. There was no modifier. If this,
Wait, what's the modifier we're talking about?
knowing such report to be false or in reckless disregard of its truth or falsity.
I'm sorry, go ahead.
No, I'm just saying, is the modifier knowingly? I'm just trying to make sure, this is literally just, I'm trying to make sure I'm following. Is that whole phrase the modifier you're referring to? I just like
Yes.
to,
Yes.
Okay, sorry.
That whole phrase is not in the subsection that the Peter-Silly court was examining. And
but just as a matter of basic English grammar, how does that phrase, knowing such to be false or in reckless disregard, not create two disjunctive? The first is where I know that it's false, and the other is when I say it in reckless disregard for its truth. I candidly, I just don't see how the district court got to reading this statute to say that it requires a knowingly false statement, because it seems, I mean, I agree the first provision requires a false statement. I just don't see how I can read the words after or as requiring the statement to be false.
because, Your Honor, I think we would argue to you that when you apply North Carolina's rules of statutory construction, which we've set out in our brief, the plaintiff's argument violates every one of them. First, North Carolina law says we have to read a statute to avoid constitutional problems. Second, it says that we have to read all of the words together in conjunction with each other and apply them. Here, the plaintiff's argument is that this statute will apply to actually false statements, recklessly false statements, apparently recklessly true statements, whatever those are, but not apply to true statements under their argument.
I mean, Mr. Dreeben can speak for himself. My understanding is they think the statute applies to a statement that is in fact false that you say knowing that it's false. So if I say I won the Medal of Honor, which I did not, and I know I did not. So if I say I won the Medal of Honor, that is a knowingly false statement. And also to a statement where honestly I don't know whether it's true or not, but I make it. So for example, if I said to you, I am descended from extraordinarily famous person X. Do I know that's false? No. Do I have it? If I say I am descended from, Henry VIII, I mean, do I know that's false for sure? I mean, I guess I don't know for sure that's false. I also have no particular reason to believe that it's true.
And that, Your Honor, is the difference. I think that the plaintiff's argument relies on an incorrect reading of what that Sullivan standard means, and we can go back to
Oh, no,
Garrison
I know what
for
the
that.
Sullivan standard means. I mean, I think that although this statute, just to clear this up, this statute was passed long before New York Times versus Sullivan, right?
It was, but it uses the same language.
Well, but what I'm saying is there's no plausible argument that the North Carolina legislature, when they enacted this statute, was actually trying to codify New York versus Sullivan because New York Times versus Sullivan hadn't been decided when they wrote this statute, right?
That is correct, Your Honor. I would note, Your Honor, that the North Carolina legislature has repeatedly revisited this statute over and over and over. The annotations to the statute show that as recently as 2018, and they haven't changed that language. And of course, we know the law that says that we presume that the legislature acts with awareness of the law. And
Right, but they can't act with awareness of a Supreme Court decision that hadn't been decided yet.
no. But once that was decided, we can presume that the legislature knew that, and when they were reviewing this statute as reflected by the legislative history, that they accepted that this is the standard.
Counsel, can I ask, so do you concede that we're in strict scrutiny land? I mean, we need to look at the statute applying strict scrutiny?
Well, Your Honor, below we argued that once you get through Garrison, it's over. And the district court disagreed with us. We've made that argument in our brief. We would stand by the argument we made, but we would also argue that as the district court found, this statute meets strict scrutiny.
Well, okay, let's assume for the moment that you do have to get past that burden. So one of the components of strict scrutiny is you actually have to show evidence in the record of alternative measures that were tried and failed before you can apply, this sort of bludgeon to what is at the very core of First Amendment speech. So what's the evidence in the record supporting the need for this statute? I mean, it's been around for what, 40, 50 years? There's been one prosecution. I mean, what does that signal about the statute?
It signals, Your Honor, I'd ask the court to consider the whole picture there, which is it has been around for a long time. Every 2 years now, we have an election cycle where all sorts of claims are made. In the amicus brief, Your Honor, it sets out a long history of all of the civil libel cases that have been filed that have involved political speech. Yet our legislature, in reviewing this statute over and over and over, and amending other portions of the statute, have not changed the statute.
Well, have they made a showing? Have they indicated somewhere that, you know, the civil remedies aren't effective, the counter speech that Mr. Freeman points to as a remedy aren't effective?
Well, Your Honor, I would argue that the fact that they've left the statute in place shows that, because they've changed other portions of the statute. That action by the legislature in and of itself is evidence. And again, I think that this plays into some of what we would perceive as the plaintiffs trying to create an impossible burden for the constitutionality of the statute. For example, the overbreadth issue that we were discussing about whether this phrase, reasonably believed to be true, is something that causes the whole statute to be invalid. Well, we know that the statute covers false derogatory statements, which is defamation. We know the statute covers that.
False defamatory statements about your political opponents that are unflattering, right? Not all false defamatory statements.
Correct. False derogatory statements about your political opponent that are intended to affect the candidate's chances.
Can I ask you that? So there's a question I had about thinking about this. So the Supreme Court has had cases about content discrimination, about viewpoint discrimination. This statute, to me, has another potential problem, which is that it is motivation-based discrimination. So we made me think is when you just said, if calculated to injure your political opponent. So this statute, I was just trying to think of an example, but imagine that someone from a political candidate's past had a bad experience with them, and they came forward as part of their healing process from a trauma. And they testify under oath, and the court believes them. I mean, do I know that this is likely to hurt this person's political prospects? Yeah, I do know that, but that's not why I'm doing it. I'm doing it because something really bad happened to me, and as part of my processing the thing really bad that happened to me, I'm bringing this to light now. As I read the statute, that doesn't, but imagine it's false and defamatory, it satisfies all. I guess what troubles me even more about this statute is that it, in addition to all the other things we've identified, seems to make whether you violate the statute turn on what's in your heart when you say it, like why you're saying it. Why isn't that an additional First Amendment problem?
Well, we would argue, Your Honor, that it's not a problem. It's one of the narrowing features of the statute. It focuses.
So it's okay if I defame someone because I want his spouse to leave him, but it's not okay if I defame him because I want him to lose an election? The
statute has to be narrowly tailored to the compelling state interest of preventing fraud and libel in elections. Remember, the Supreme Court in McIntyre said that that is a compelling state interest, preventing fraud and libel. They specifically used that word. And that's where we would focus the court on, is that part of the statute actually focuses us in on that very issue and furthers that compelling state interest. Your Honor, going back to the issue of this little phrase, reasonably believed to be true, an overbreadth challenge, we'd ask the court to remember, the United States Supreme Court said in United States versus Williams, to strike down a statute on overbreadth grounds, it must be shown the statute's overbreadth is substantial, not only in an absolute sense, but also relative to its plainly legitimate sweep. And then in RAV, in the concurrence actually, the court goes on to talk about, in addition, Williams also says that you would have to show that the statute is not susceptible to limitation on partial invalidation. Here, this statute, we talk about hypotheticals of reasonably believing to be true and whether that falls under the language of the statute. This statute is clearly focused on preventing false derogatory speech. That's the focus of the statute. It ties in directly with what the compelling state interest is behind the statute.
Let me ask you about that, because your friend on the other side says it isn't in at least two respects. So under this statute, I can completely lie about my own background. I can falsely claim to be a Medal of Honor winner. I could Photoshop a photo that puts me with someone that I think that voters will really like. you know the examples. I could lie in 1,000 different ways that benefit me, and the statute has nothing to say about that. I could also lie about a tremendous number of issues of tremendous public importance that are not literally about my opponent, but every reasonable person is going to understand are about my opponent. Why isn't that a problem? That the statute only seems to criminalize saying intentionally really mean things about your opponent, but you can, in the context of an election, lie about literally anything else, and the statute doesn't care.
Well, Your Honor, for a number of reasons. First of all, in terms of under-inclusiveness, we've cited the law to the court, the Williams-Yulee case that talks about there is no freestanding under-inclusiveness limitation.
But it causes us to question this since, I mean, because a more cynical view is that this is a statute that is designed to protect, I mean, I think one of the amicus briefs says this. A cynical view is this is designed to protect certain people from having certain things said about them during political campaigns that they don't want said about them.
Well, Your Honor, the reason that this statute is not under-inclusive is because it focuses on that area of speech that is traditionally not protected by the First Amendment. That is defamation. When you talk about false laudatory speech that the other side talks about, well, you get into Alvarez. And what did Alvarez say? Alvarez said that's outside of the defamation area that we're talking about here. Defamation is one of those traditional categories that the courts have consistently said is outside the protection of the First Amendment. That's the focus of this statute. So that's why I don't think it's fair to put the burden on us in terms of under-inclusiveness, because this statute's focused in on that very specific area. And as
Could I ask a question about the application of this statute here to this case? So, you know, one of the objectives, you say, of the statute is to protect the electorate and ensure that accurate information is disseminated to those who have to make a decision with respect to candidates. But how does this statute really do anything in that regard? I mean, the criminal justice system just seems really ill-suited to achieving that end. And here we are, what, 2 years, I think Judge Rushy made the point, after the election, and we still haven't achieved any kind of resolution with respect to the merits of this case. I mean, isn't counter speech the more effective way to go here?
Well, Your Honor, I would argue a number of points. First, the district court talked about counter speech and talked about how counter speech is effective if there's time to do it, and talked about the case law behind that. One of the points that the plaintiffs make in their reply brief, which unfortunately I don't get to respond to, is
Well, you're here today, so.
and I'm going to. They raise the issue of technology, and I think they're trying to sway the court that, hey, we live in this world where somebody can, we're in the 24-hour news cycle. Well, there's a flip side to that, of course, which is we're also in an era of early voting. And in North Carolina, you can vote for months and months and months before Election Day. There's not just Election Day anymore. And if on Thursday night at 6 o'clock, there is a false and defamatory report on the evening news and about candidate A, and I see that and I say, well, I'm going to go vote for candidate B. And the next morning.
How does criminal liability solve that? I mean, I guess your argument is it's chilling, right? It chills you enough that you won't say the false thing. But I think Judge Diaz's point is a good one. Maybe you can't solve every false defamatory statement about a candidate, but speaking immediately after it is your best chance, rather than a lawsuit 2 years later holding someone criminally liable.
Well, I would argue to the court that it would take 2 years or however long it would take, but it would have the effect of preventing that speech that is outside of the protection of the First Amendment, which after all is the point. And I think that you get into the balance of, is the plaintiffs are asking the court to substitute its judgment about the efficacy of this statute for the legislatures. And where is the balance there? Where is the line? That's impossible to say, but I would stress to the court, this law is the legislature's law. It's the will of the people of North Carolina. And they're asking a federal court to come in and tell the state legislature that it cannot have this law. And we would argue that, as the district court correctly found, this law is constitutional under Garrison. It's narrowly tailored to the compelling state interests, and we would ask the court to affirm the district court's judgment.
Thank you, counsel.
Thank you.
Mr. Dreeben, you have some time for rebuttal.
Thank you, Your Honor. Just a few brief points. First, on the meaning of the statute, in addition to the contrast between A8 and A9 that the court has already drawn. If you look further down in the statute 163-274, there are two provisions, 13 and 14, that explicitly apply to false representations. So the legislature knows how to target false speech if it wants to do that. And for the reasons that have been discussed, it did not do that grammatically in this case. All statements, because the prosecutor can always go that route, and anyone who is thinking of making a comment in the political context is aware from the face of the statute that there is a risk of prosecution, and that is a dangerous consequence of the meaning of the statute. Now, second, my friend talked about how the North Carolina legislature has passed this statute on a number of occasions or amended the general provisions, but in no instance did it ever come forward with evidence that this statute is necessary to accomplish a compelling interest in electoral integrity. And it could have tried, for example, to say, well, the states that have these statutes have much cleaner campaigns and candidates are far more respectful, careful of the truth, and the states that don't have them, the 40 states, lies are rampant and campaigns are sullied by false statements. It has done nothing to make any demonstration of that kind. I don't think any demonstration of that kind could be made. And it therefore has not satisfied the compelling burden in the First Amendment context of coming forward with empirical evidence, not just statements or hypotheses or speculation. And this court's own precedents, as you pointed out, Judge Diaz, require that there be empirical evidence. The Supreme Court reaffirmed that requirement just last term in FEC versus Cruz, 142 Supreme Court, 1638 at page 1653. In the First Amendment context, evidence is needed to sustain a burden on political speech. The other argument that my friend makes is that Garrison puts criminal defamation statutes on a sound frame. I don't agree with that, but assuming that that is true, there's a mismatch between the interest that the state is asserting in this case and the purpose of criminal defamation statutes. They grew out of a regime in which there was an effort to prevent people from engaging in duels, and so there was a desire to provide a governmental remedy that would encourage people not to go out and walk off 10 paces and fire bullets at each other. Criminal defamation may have outgrown that purpose, and then it just serves as a reputation-protecting mechanism. But in this case, the state's brief, as I read it, is not really saying that this is needed to protect candidates' reputations against scurrilous allegations in campaigns. And I think in America campaigning, that would be very difficult to sell. What the interest that's asserted is in electoral integrity, protecting the citizens and the voters' right to make the decisions about who to elect. And that is not aligned with the interest in reputation protection, and it is at odds with our fundamental commitment to democracy, where the voters decide based on the competing merits of the candidates, and they're able to go to the polls and then express their views on it. And then finally, the court has recognized that counterspeech is the preferred remedy in Alvarez, in the political context, in the Citizens United case, and the idea that counterspeech has become somehow less effective in this environment where politicians have access to the airwaves and the internet to respond to each other, as occurred in this case, does not accord with our political reality. So,
Can I ask a brief question about that? So that's true, and we've got all these technological advances that provide information, but there's also the potential for greater misinformation. So, I mean, why wouldn't a statute like this counter that simply by deterring that kind of misinformation?
I think, Judge Diaz, the fundamental problem with a statute like this is it puts governmental officials in the position of being arbiters of truth in a political campaign. and it invites abuses, such as one candidate filing charges with the Board of Election against the other and being able to go out and say in press, I'm invoking the machinery of the state because these lies merit prosecutions. North Carolina's law is particularly poorly tailored because it allows any of the more than 40 district attorneys to initiate a prosecution, even if in a case like this, the Board of Elections investigates and concludes that there is no merit to a charge. It also provides for the opportunity of individual citizens to go to court and ask the court to find a prima facie case and initiate a prosecution, and it permits the appointment of special prosecutors for that purpose if all of the DAs in the state turn it down. And that kind of a blunderbuss approach of bringing the state's machinery and putting a thumb on the scales of candidate debates in a political campaign is likely to do far more damage to the political process than any minor deterrent effect, which I think actually translates to First Amendment chill rather than a benefit. And these are not new ideas. In the report on the Virginia resolution that Madison wrote to decry the Alien and Sedition Act, he specifically referred to candidates as being subject to vigorous public debate, and that is how our democracy works. That passage is quoted in New York Times versus Sullivan. It remains just as true today. North Carolina's law crosses that line, and for that reason, we submit that it's unconstitutional.
All right, thank you very much, Mr.
Thank you.
Freeman. Thank you, counsel, for a case ably argued. We would typically come down from the bench and greet you personally. We have unfortunately not been able to resume that tradition. I hope someday we will, but that day is not yet here. But we nonetheless very much appreciate your arguments this morning. Thank you very much. All right. Second case is Solis Flores versus Garland. Mr. Winograd, did I have that right?
Yes, Your Honor.
Go ahead, sir.
Thank you, Judge Diaz, and may it please the court.
Welcome back.
Thank you. The primary issue in this case is whether my client's conviction for receipt of stolen property qualifies as a crime involving moral turpitude. The court should hold that it does not for two independent reasons. First, to obtain a conviction, prosecutors need not establish that the defendant intended to permanently deprive the victim of property, as has long been required under board precedent, or at a minimum, should be required under board precedent. Second, at the time my client pleaded guilty in 2000, prosecutors could obtain a conviction based on a theory of constructive receipt for passively receiving benefits derived from the sale of stolen goods. Unless the court prefers otherwise, I will address the arguments in that order, followed by our request for voluntary departure. Now, the government does not dispute that a person can be convicted for receipt of stolen property in Virginia, even if they did not intend to deprive the victim of property. The government instead contends that the board has never required such an intent for receipt of stolen property to qualify as a CIMT, but we believe the government is mistaken. In its 1944 decision in Matter of K, the board held, quote, where property is acquired without knowledge that it is stolen or without intent to deprive the rightful owner of his possession, the offense does not involve moral turpitude.
Does it matter?
I'm sorry,
Go ahead.
where does it say permanently in that? Can you read that again? Does it say permanently? I didn't think it did.
They did not use the word permanently. However, in a subsequent unpublished decision that we cite, and include a copy of with our reply brief, they do specifically say permanently. And also, in terms of the background, just a few months before Matter of K was issued, the Attorney General himself issued a decision called Matter of T, which upheld the permanent versus temporary distinction in the concept of theft. So we
Right,
think...
because in theft, the person's actually taking it from the rightful owner. And you have to show that they did that culpably, right, with a bad state of mind. So they did it with intent to permanently deprive. But receipt of stolen goods is different. You're not the one who's taking it. You're receiving it from someone else who took it or from a third, down the chain. And the culpability there, the government says, is taking it with dishonest intent, right? You know it's been stolen, and then you take it. So why isn't the government's argument about the culpable state of mind, it's different between those two things, and why isn't that okay?
Well, that gets into our second argument about whether the board would have to, should include a permanent deprivation requirement. And we think joyriding provides the clearest example. So the board has long held that joyriding is not a CIMT precisely because the defendant need not intend to permanently deprive the owner of the vehicle. So if a person who physically takes a car to go joyriding does not commit a CIMT, it follows that a person who receives a car simply to continue joyriding also does not commit a CIMT.
Right. I mean, they didn't receive something they knew was stolen, because it wasn't stolen to begin with. And they didn't do it with the dishonest intent because they intend to give it back. So joyriding, it's not a CIMT whether you receive it or you take it.
Well, even in a case where the original thief did steal the car and then lent it to someone whose intent was just to take it for a joyride and then return it to the owner, even in that case, we believe that person would be liable under Virginia law.
Where's the dishonest intent? If they take it thinking, the rightful owner is missing their car, I'm going to take it for a spin and then give it back to them and correct this theft.
We believe even that scenario, there's a difference between dishonest intent and intent to steal, or as the Virginia cases refer to it, malo animo, which is a dishonest intent, and animus ferende, which is intent to steal. So we acknowledge, of course, that this crime has been interpreted to require malo animo, or dishonest intent, but given that Virginia courts have held that it does not require an intent to permanently deprive, we think joyriding itself, certainly a person who goes joyriding does not have an honest intent. They intend to use someone else's property without their permission, even if they intend to ultimately return it to the original owners.
I mean, you're hypothesizing a case where someone receives a car they know was stolen, knowing that it was stolen, and then their intent is to return it to the rightful owner. And you're saying that's dishonest intent. That satisfies all four elements of the Virginia statute.
Yeah, in Bazemore, the Virginia Court of Appeals held that an intent to permanently deprive is not a required element of receipt of stolen property, even as, of course, we know that the defendant must know that the original property was stolen. So the Virginia courts themselves have recognized this nuance in the statute.
Is there any suggestion at all that they've ever applied this statute to not even Robin Hood? I was going to try to give an example of altruistic joyriding, right? I'm going to go around and find all the stolen cars and return them to their rightful owners.
I was going to say Henry VIII.
Yeah.
Well, joyriding is but one example. It could apply to any instance of property that is borrowed without the consent of the owner. But we don't need an actual case when we have an actual prosecution, when we have a decision of a Virginia appellate court stating as much.
Do you have a decision of a Virginia appellate court applying it to altruistic conduct?
I don't think that I wouldn't classify joyriding as altruistic.
No, it has the crucial fact that you're positing is intent to return it to the owner. That's what keeps it from being dishonest intent. I know it's stolen, but I intend to give it back.
I think even in that case, there would be dishonest intent. I think using someone else's property for any period of time is dishonest, even if you ultimately intend to return it, and that was especially so for something as valuable as a vehicle. But we can see there are not specific joyriding prosecutions under the statute, although the facts in Bazemore did involve a defendant who was driving a vehicle without permission, and he claimed that the prosecutors failed to establish an intent to permanently deprive, and the Virginia Court of Appeals said, well, that's not required under the statute.
Can I ask you a related?
Yes.
Do you know of, so I guess I'm thinking of the daisy chain of joyriders problem. So let's just say that I see a really nice car on the street that I decide I want to take for a ride, and I take it for a ride, and then I'm a little tired. I'm done. And so then I see Judge Diaz, and I say, hey, this car's really great. You should take it for a spin too. Do you have any situation, and I tell him this is a car that I'm joyriding. Do you have any case where Virginia has ever prosecuted someone for receiving stolen property on a fact pattern that remotely resembles that?
No, conceitedly we don't, but we are relying instead on the holding of Bazemore that's such that a permanent deprivation is not required. And this court has held in many
Well, but
cases.
it also strikes me that it would be tricky to square with the language of Whitehead, right? Because Whitehead says the property was previously stolen by some person other than the accused. Couldn't Judge Diaz defend in that situation by saying, Judge Heitens didn't steal it, he was joyriding, and there's a distinction between stealing something and joyriding in it?
Certainly, Your Honor, and if the chain of events was joyrider to joyrider, then there couldn't be knowledge that the property was stolen because joyriding does not require an intent to permanently deprive. I'm referring to a scenario where the property was originally stolen and then perhaps given to another person who intended to use it temporarily and then return it. Could be a piece of jewelry, for example. But again, we're relying on the conduct that could be criminalized as held by state appellate courts. Now, and again, the government argues that the mere fact that theft is different from receipt of stolen property is enough for the board to treat them as different for immigration purposes. But we don't think that answers the ultimate question of whether there is a rational basis for the distinction. For example, assault and battery are technically, conceptually, two separate crimes, but the board has always treated them identically for immigration purposes. And if the board was to impose a requirement for one, but not the other, this court would not simply say, well, they're two different crimes, that's permissible. It would examine whether there is a rational basis for that distinction. Now, a separate reason, yes.
What's odd about this joyriding hypothetical that we keep talking about is, honestly, the question I keep coming up with, why isn't joyriding a crime of moral turpitude? And I guess part of me, the answer might just be, just because historically speaking, it's not been understood as a big deal. And maybe that has something to do with cars didn't used to have locks, and this was just the kind of thing people did in the 1930s. But why why wouldn't it be rational for the board to say, look, yes, we have said that joyriding is not a crime of moral turpitude for historically contingent reasons involving automobiles and the tradition of jalopies and things like that. But we have always understood, knowing, to go back to what Judge Rushing said, when someone gives you something and you know the thing they're giving you is stolen, you're not supposed to take it. It's a morally culpable thing when someone says, do you want this thing? By the way, I just stole it.
Well, the board has held that joyriding is not a CMT going on
Sure.
80 years. And even at this point, if they were to reverse course, that holding could not be applied retroactively.
Oh, no, I totally agree with you. But what you said, they need a rational basis. Why isn't the rational basis is, look, as a matter of first order principles, we may today decide that joyriding was a crime of moral turpitude, but historically speaking, it's always been understood to be a minor offense. We're going to continue to recognize the fact that it's a minor offense. But the fact that we do that does not mean that we're also going to say that taking something you know was stolen is not a crime of moral turpitude. Why isn't that a rational basis for treating them differently?
For one, the board has never actually articulated that basis. I mean, we acknowledge that there have been many cases that don't refer to a deprivation requirement, but the board has never even spelled out its reasoning as much as Your Honor simply did. So we think at a minimum, the court.
But they have. They've said repeatedly that when it comes to the receipt offense, the moral culpability is taking something from another person that you know is not legitimately theirs. They've said over and over that's the rationale in the receipt of stolen property. They've given us that reason. It's that taking something that you know was stolen is a morally culpable thing to do.
I don't think it's as morally culpable if you intend to ultimately return it. And empirically, it's hard to measure, but one would think that receipt of stolen property is not as reprehensible, or at least is either as or less reprehensible than taking property in the first place. So we think, at a minimum, we think the board should spell that out in more detail, as the government itself originally requested in its motion to remand. So just to move to our entirely separate argument, apart from the permanent deprivation requirement, which is that at the time my client pleaded guilty in 2000, a person could be convicted for constructively receiving stolen property, much like the defendant in the Whitehead case, whose conviction was affirmed by the Court of Appeals in 2008.
And then unanimously reversed by Virginia's highest court?
Yes, it was reversed, but our argument, we recognize, of course, it was reversed, but in terms of the ultimate issue is, did it establish a realistic probability that other defendants were previously convicted of engaging in similar conduct? So just to clarify our argument is not that courts are limited to considering decisions that had been issued at the time of conviction. Our argument is that when a conviction is affirmed by an intermediate appellate court, that decision creates a realistic probability, both going forwards and backwards, that other defendants were convicted of similar conduct. Now, if that decision of the intermediate appellate court is later reversed by the state's highest court, clearly there is no longer a realistic probability going forward that people could be convicted of similar conduct. But it doesn't magically erase the realistic probability that such conduct was prosecuted in the past.
What is your best case for the that is, shall we say at minimum, an unusual way to go about thinking about law? What is your best case for the proposition that that's what we do?
Well, because this court has held in other cases that you look to decisions of state appellate courts to look at the conduct that has been prosecuted and could be prosecuted.
But what's your best authority for the proposition that the decisions we look at include decisions that were unanimously reversed by the state's highest court?
Your Honor, I don't believe any court has ever considered that. I think this is an open question under the categorical approach about what you do when you have a decision of an intermediate appellate court, which otherwise, I mean, it's undisputed that if the Supreme Court had never overruled the intermediate appellate court in Whitehead, that we could rely on it, even though it was entered after the conviction. But we just think as a practical matter, and the realistic probability test is a practical test, the fact that the decision was ultimately overruled by the state's highest court doesn't erase the realistic probability. And to be...
Can I ask you a question
Yes.
on voluntary departure? I want to make
Yes,
sure.
yes.
So let's assume for the sake of argument that we have jurisdiction to review it, and let's assume for the sake of argument we think that the BIA was wrong in construing the regulation. Why isn't the remedy a remand to the BIA rather than a remand to the immigration judge to enter voluntary departure?
Oh, well, Your Honor, simply as a practical matter, I believe this court can only remand to the BIA, and then the BIA would in turn remand to the immigration judge for further consideration.
Can I ask
Yes.
you about that?
Yes.
I'm under the impression there's a federal regulation that says when you petition a court and seek a judicial remedy, you've made an election not to pursue voluntary departure. So the regulation says the voluntary departure order extinguishes. It no longer exists because your client made the choice, made the election to pursue the judicial remedy. So we have precedent saying we can't send it back for voluntary departure because the election has been made.
No, the regulation Your Honor is referring to is only referring to voluntary departure orders that have been granted. Here, the board did not grant voluntary departure.
The IJ granted voluntary departure, and then you sought relief at the board, and then you sought relief here, and that's what the regulation is talking about. It says, upon filing a petition for review or other judicial challenge, the grant of voluntary departure terminates automatically on the filing of a petition or other judicial challenge. And instead, that alternate order of removal, which the IJ entered here, that immediately takes effect. So the alternative order of removal has immediately taken effect, right?
Yes, he's under an order of removal, but my point was there is no longer any grant of voluntary departure that can be extinguished by filing a petition for review because the board itself did not reinstate the period of voluntary departure.
But doesn't Lee versus Holder, doesn't our case in that say that we can't send it back for a do-over on voluntary departure once you've sought judicial relief?
I'm not familiar with that case. The government certainly hasn't cited it. I would be happy to address it in a 28-J letter.
All right, thank you, counsel. Ms. Pergolesi, whenever you're ready.
Very nicely done. Thank you. Good morning, Your Honors, and may it please the Court. Sarah Pergolesi for the government. I'd like to start with the Court's concern about the joyriding daisy chain hypothetical or the Good Samaritan joyrider. In really digging down on this issue and preparing for oral argument, I have only found one Virginia unpublished Court of Appeals case that even closely ties to this exact hypothetical, and in that case, the defendant lost. In that case, it's, and I'm happy to file a 28J about it because candidly, I didn't
You said
cite
the
it.
defendant lost as in the defendant was convicted?
The defendant was convicted. The defendant tried to raise a defense that he intended to return the stolen vehicle. And the appellate court found that the record did not support that defense at all. Of course, the court did not say that that defense did not exist, but it found that the applicant, or the defendant, provided no proof that he intended to return the vehicle.
What's the name of the case?
It is. And again, I'll file a 28J as well, just so that the court has it in writing, but it's Jones versus Commonwealth, and it's 2017 Westlaw 586519. And again, it's an unpublished Court of Appeals case from 2017. In that case, the defendant was found in a car, driving a car that was reported to be stolen, and he was driving with a man who stole it. He alleged that the man just told him, hey, I have a car for the day. There's some term about joy-ridden cars that I don't have off the top of my head, but he said, I have this car for the day, let's go on a drive. The police officer who apprehended the defendant and his passenger found them in an area where cars were typically dumped after being stolen. And the defendant essentially argued that he had no knowledge that the car was stolen and that he intended to return it. And the Court of Appeals found that there was no support for either of those claims. And so as Judge Rushing made point of in questioning the petitioner, a critical element of this Virginia receipt crime is that the defendant knew that the property was stolen, not that the property was borrowed, not that the property was taken impermanently, but that it was stolen. And Virginia law requires that theft is a permanent deprivation. And so...
The best hypo I've come up with, I assume you have seen Ferris Bueller's Day Off?
Yes.
So let's assume that the guys in the parking garage know that Ferris is joyriding that day, and that they then in turn go joyriding in the Ferrari that they know is itself. So in your view, under Virginia law, those guys are not guilty of receipt of stolen property? So I'm joyriding the car, and then I leave it in a parking garage, and a parking garage attendant who knows that I am joyriding in the car themselves decides to take the car for a joyride. In your view, that person is not guilty of receipt of stolen property because they don't know that I stole the car.
From my understanding of Virginia law, which again is not very precise on this issue, that is the closest case, this is the closest case I found. It's unpublished, it's from the Court of Appeals. There doesn't seem to be a lot of law about this in general, but yes, that's my understanding. If the state cannot prove that the vehicle was stolen, oh, and that's another unpublished case
So
that I found actually, if the state can't show the vehicle was stolen, that first joyride, if Ferris joyrides, he hasn't stolen it.
That's what so implicit in what we've been saying, but I just want to make sure that when the Virginia Supreme Court says that the property was previously stolen, they mean taken with an intent to permanently deprive the owner of the property. And so if the first person is themselves a joyrider, that property was not in fact stolen within the Virginia law?
Again, that's my understanding of the Virginia law, which is very sparse. It seems to both adhere in that stolen element, but it also, again, there's very little case law about this issue that I could find. But the Virginia law also seems to, in describing guilty knowledge, the knowledge requirement in general, that the property itself was stolen before the recipient takes control of it. They also call this guilty knowledge and sort of allied that knowledge that the property was stolen requirement, or even the first requirement that the property in fact was stolen, with the fourth element, as Virginia law describes it, which is that dishonest intent. And I think, Judge Rushing, you also mentioned that. I, again, could not find any Virginia law that clearly describes what dishonest intent means. But from surveying the state law, it seems to ally those two things. That dishonest intent really seems tied to the knowledge that the property itself was stolen. And then the choice, the actus reus here, of receiving that stolen property knowing that it's stolen.
Do we have to disagree with the Ninth Circuit's decision in Castillo-Cruz to rule in your favor?
Yes and no. So Castillo-Cruz is imprecise in some ways that the court, in ways in which the court doesn't have to follow that reasoning by any means. In Castillo-Cruz, the Ninth Circuit focuses entirely on the board's case law regarding theft, and doesn't seem to really grapple with or acknowledge the court's separate and distinct, or the board's separate and distinct long line of precedent that receipt crimes are turpitudinous for a different and distinct reason. As the 10th Circuit in De Leon really parsed out the sort of faults in the 9th Circuit's reasoning, the court can similarly find that the 9th Circuit reasoning is not persuasive here. Excuse me. I think if the court doesn't have any further questions, what I'd really,
Can I ask you about voluntary departure?
could I?
The petitioner is correct that you do not cite 1240.26I, which we have taken to deprive us of jurisdiction to send a case back for redoing voluntary departure once the election has been made. So what's your position on that?
I also, candidly, am not familiar with the Lee case and would have to look at it, but I do want to note that that regulation was both the regulation in effect when the board's decision was issued in this case, and is not part of those enjoined rules that, it's currently applicable, and so yes, it would.
It's been in effect since 2009, and it's not been enjoined. So why didn't you cite it, and what does it mean for us?
It's a very good question, Your Honor. I should have cited it. It's definitely, it's another reason why essentially the conclusion in this case is foregone when it comes to voluntary departure, and it can be a separate and alternative basis for the court to deny the petition on those grounds, that essentially that the court can't remand for that basis. I candidly need to look at Lee because I'm not sure if it's just that the court cannot remand for reconsideration of voluntary departure alone. I don't know if granting the petition for review and remanding would sort of nullify the petition of the order that terminates the voluntary departure.
It doesn't have anything to do with the CIMT ground. It just has to do with voluntary, can we send it back for a redo on voluntary departure, and the regulation tells us that an election has to be made, and once that hard choice, as we put it in Lee, quoting the Supreme Court in Dada, once that choice has been made, we can't give the petitioner a second bite at the apple.
Again, just candidly not being aware, knowing the case closely enough, but I would agree, certainly, if that's.
So it may well sound like it may well be that we don't get to this question, but I guess I noticed a rather conspicuous fact in your brief, which is that you don't, as I see it, defend let's assume that we somehow get through all of these procedural maths to the actual language of the regulations. I noticed that you don't actually defend the BIA's reading of the regulation, which is perhaps most charitably described as difficult to square with the text. Would you agree with that?
Yeah, again, very candidly, we're not arguing the government's position is not that the immigration judge complied with this regulation. It's pretty clear cut, or that the regulation doesn't say that the immigration judge shall inform the petitioner of these requirements for voluntary departure before granting it. And so our arguments are, based
and then
entirely.
I guess on that front, and again, maybe we don't get there for the reason that Judge Rushing mentioned, but assuming that we were to, you sort of assert that we don't have jurisdiction, but then you quote, the statute says we have jurisdiction over errors of law. Why wouldn't it be an error of law?
Yeah.
Again, assuming we get past the Judge Rushing point.
And I think it was almost an effort of inclusiveness here, but yes, the challenges that we're discussing both in our briefs and today are certainly questions of law. So the court, of course, has jurisdiction over questions of law, even in the voluntary departure
And then the last
context.
question on that is the assertion, to the extent you make one on the merits, is you say he can't satisfy the elements of a due process claim, and he responds, fairly enough in his reply brief, that his blue brief doesn't even contain the words due process. So what authority is there for a proposition that it has to be a due process claim as opposed to you just violated your own regulations claim?
Right, well, I guess what I'm trying to square is what kind of argument is just the sole argument you violated the regulations, and under this court's precedent.
That you should have complied with the regulations.
Well, under this court's precedent, an argument that a regulation wasn't complied with in Morgan, when you make that argument that a regulation was violated, you also have to show prejudice. That three-part test in Morgan applies even if you don't call it a due process argument. A challenge that the immigration judge violated the regulations which set out regulatory process.
Is that an argument?
It's hard for me to.
I'm sorry to interrupt, but is the prejudice argument one that we can consider given that the BIA never reached it?
There is an exception to Chenery in that if the conclusion is foregone or obvious, then the court can decide something that the board didn't decide. And here, the petitioner never even alleged before the board that he was prejudiced by this error. He just whole cloth says that an error occurred, and without tethering that argument to any sort of effect that error has. Again, yes, if this goes back, if the court agreed that it was a clear violation of the regulation, the board would be able to decide prejudice. And here, it would have to, because the petitioner never alleged that the harm prejudiced him. But yeah, if the court has no further questions, I would just really like to conclude briefly in, again, pointing to the very clear line of board precedent with respect to receipt crimes, in that the board has said consistently that the turpitudinous, the morally reprehensible conduct, the thing that is turpitudinous, is the knowing receipt of the crime, the stolen property. And therefore, knowledge that the goods were stolen is essentially intent is inherent in that knowledge requirement. Knowledge is both a requirement when it comes to, just as a matter of criminal law, as I understand it from first year criminal law, knowledge obviously is one form of an intent when it comes to crimes, as opposed to negligence, recklessness, et cetera. But in this receipt context, knowledge is also doing more work. Knowledge is showing an intent to control the property, to treat the property a certain way. That knowledge that the goods are stolen inheres a different kind of intent that is turpitudinous, and that the board has the authority as the adjudicator and interpreter of the term moral turpitude. The board has complete latitude to determine that this kind of crime is turpitudinous, and it has that complete latitude deserving of deference to determine that theft crimes and receipt crimes are different and should be treated differently in this context. And with that, if there are no further questions, I'll conclude. Thank you, Your Honors.
Thank you. Mr. Winograd, you have some rebuttal?
Thank you, Your Honor. Just to return to the receipt of stolen property issue first, Your Honor is correct that in Ferris Bueller's Day Off, assuming the garage attendants knew that Ferris and Cameron were joyriding, they themselves would not be liable under the statute. But I think you could imagine a different scenario where it would apply. So if a person steals a car and then allows a relative to borrow the car, and the relative knows that the car was stolen, and in the course of borrowing the car, they realize that the car actually belongs to someone they know. And then a few hours later, they decide, you know what, I'm going to return the car to the victim, to the chagrin of the relative who stole the car. If they were to do that and they were to pull up to the victim's property, they could be arrested on the spot for receipt of stolen property, because they knew at the time they took the car that it was stolen, and they did not, and they used the car, and they did not intend to permanently deprive the victim of the car.
And I guess to return to Judge Rushing's point, your view is there is a realistic possibility that person would be prosecuted for receipt of stolen property?
Yes, because it satisfies all the elements of the crime as laid out by Virginia appellate courts. And under this court's precedent, that's all we need to satisfy the realistic probability test in our view. And also, Your Honor's question about the Ninth Circuit, we believe that this court would have to disagree with the Ninth Circuit in order to rule in the government's favor. We realize that there's somewhat of a lopsided split against us on this point, but we think this court would have to join the other side of the split. And we think at a minimum, you know, a remand is warranted, as the government initially requested, for the board to further percolate before the board and really explain why the permanent deprivation requirement should apply in the theft context, but not in the receipt of stolen property context. Turning to the voluntary departure issue, just on a quick reading of the regulation in question, again, our position is that if the board does not reinstate voluntary departure, there is no grant that could possibly terminate. But the regulation does say that the board shall advise the alien of the conditions provided in this paragraph in writing if it reinstates the immigration judge's grant of voluntary departure. So again, we'll address this more in a 28J letter, but the regulation itself seems to contemplate that the revocation only applies if the board actually reinstates the period of voluntary departure, which it did not do in this case. And finally, just with
Now, that would have to, but given the government's complete failure to rely on that regulation, the only way we would have to, I mean, we probably could consider it either way, but the only way we would have to is if it's actually subject matter jurisdictional, right?
correct, and I can't conceive of any basis in which it would be, in which it would go to subject matter jurisdiction. It's in a regulation, not a statute. And just with respect to prejudice, again, under Chenery, the board never considered prejudice, so it should go back. In matter of Gamero, which is the case we rely on in our briefs, the board remanded because the IJ failed to comply with the requirements and didn't consider prejudice at all. So we think at a minimum, a remand, the court should remand to the board on the voluntary departure issue, and then the board can further determine what, if any, prejudice inquiry is required.
All right.
Court has no further questions?
Thank you very much. Appreciate counsel's arguments. We would typically come down and greet you, but we can't do that today. But thank you nonetheless for your able arguments. So we're going to take a short recess before moving on to our next two cases.
This honorable court will take a brief recess.
Third case this morning, Ponce Flores versus Garland, and Ms. Carl.
That's correct, Your Honor. Good morning, Your Honor. Gabriela Garcia Carl. I'm here on behalf of the petitioner, Mr. Jesus Ponce Flores. Can you guys hear me? Is the mic okay? Thank you. The agency found that Mr. Ponce Flores, a greenlit gang defector who was recently stabbed by MS-13 while in U.S. custody, will face severe harm rising to the level of torture if he is deported to Honduras. The agency erred, however, when it held that that torture would not be by the hands of the Honduran government or by its acquiescence. In so deciding, the agency made 3 fatal errors. The first error was the agency applied an incorrect legal standard for torture when it held that Honduran police would not torture Mr. Ponce Flores. The second was the agency failed to heed this court's decision in Cabrera Vazquez, Cruz Quintanilla, and the Attorney General's precedential decision in matter of OFAS that it must factor the actions of low-level Honduran police into its government acquiescence analysis. The agency in this case also failed to meaningfully engage or provide cogent reasons why it did not engage with evidence, legally relevant evidence to the government acquiescence analysis. A dissenting board member, would have remanded on this basis alone. And this court has remanded on this basis in Alvarez Lagos and Portillo Flores. The first 2 issues are subject to a de novo review. And the last issue, we argue, should be an abuse of discretion standard of review. That said, even under a substantial evidence standard, we believe that there is no reasonable fact finder could hold that the Honduran government would not torture Mr. Ponce Flores directly or do so with government acquiescence. I'll begin. We're asking the court today to grant the petition for review and vacate the agency's decision and reverse the agency's decision. And I'll begin with the risk of torture by and with government acquiescence. In Cabrera Vazquez and matter of OFAS, this court and also the agency held that one must consider the actions of low-level police officials when engaging in the acquiescence analysis. This court has also held in Alvarez Lagos and Portillo Flores that CAT analysis is highly fact-specific, and any analysis involved in CAT analysis has to reflect the individualized facts of the petitioner. And in this case, the agency's case, that CAT analysis does not reflect particular individualized facts that are extremely relevant to the analysis. First, the agency failed to consider that Mr. Ponce Flores is a greenlit gang defector. And what that means is that he's a high priority target for MS-13 and therefore also for any corrupt police officers within the Honduran police force. The MS-13 has recently stabbed him, indicating that he's more proof that he's a high priority target. And he's been in protective U.S. custody since that event. In addition, he is someone that the agency ignored these factors, that the police would be easy to find because he has tattoos, which identify him.
I thought the agency mentioned the tattoos a number of times and his statement that he'd covered it up with other art. And the IJ acknowledged that they might not totally cover it, but they cover it somewhat. There was discussion about that, wasn't there?
Yes, Your Honor, that's correct. But what the agency ignored in her consideration is while there were some tattoos that were covered up, there were several that were not covered up that would identify him as someone who has gang ties, even if he has left the gang. And so those tattoos put him at risk. And that's an example of one of the individualized facts that was ignored in this case. Another aspect that wasn't fully considered is the deportation process. Mr. Ponce Flores is going to be transferred from U.S. custody directly into Honduran custody with an official record that identifies him as someone with gang affiliation, although, again, he's left the gang. And that's because he has a conviction for gang participation. And so when he's being handed over to Honduran police, it'll make it much easier for him to find and both be victimized by corrupt and non-corrupt police officers. The corrupt police officers, obviously the reason would be that they're working with MS-13, but for the non-corrupt police officers in Honduras, gang participation or gang membership has been criminalized, and they're not going to concern themselves or ask him questions about whether he's left the gang or not. They're going to make assumptions about him because of his tattoos, because of the official record he has from the U.S. government, and they're going to.
Wasn't there expert testimony about this that the agency considered?
The agency disregarded evidence. So the agency really focused on, I assume the court, and please correct me if I'm wrong, is referring to Dr. Gutierrez's testimony about what would happen in the transfer from United States to Honduras. And there, the agency really focused on just parts of the testimony, but actually on cross-examination, Dr. Gutierrez, and also in her affidavit, was very clear that the process for Mr. Jesus Ponce Flores specifically would be that because of his official record for the official criminal record that has this conviction for criminal gang participation because of his tattoos, that he is very likely to be transferred to Honduran police who would harm him, either because they're corrupt or because of how they treat gang members, even former gang members in Honduras. And the other thing that is critical to this case, an individualized fact that cannot be overlooked, and that this court and also the Attorney General have urged the agency to take into consideration, is the actions of the low-level police officers. And again, that was a matter of OFAS and Cabrera Vasquez. In both of those cases, and when you're considering government acquiescence, you have to look at the actions of those low-level officials as well. And that's something that the agency didn't engage with at all in her analysis.
Did the agency discuss a lot of documentary evidence that you all submitted about what local police are doing, and that the agency also discussed, well, there's been substantial efforts to try to get rid of the bad actors, but there still are bad actors, as evidenced by the documents. I thought there was discussion about that. So what's the low-level actor evidence that the agency totally ignored?
She ignored, and this is something that this court has held in Alvarez Lagos and Portillo Flores is really important not to ignore, which is the credible testimony and the credible affidavit from the petitioner himself talking about the actions he experienced as and observed as a greenlit gang
I thought
defector.
the agency mentioned that. I thought I read where she talked about his testimony and his affidavit. What he said happened to him, that he was stopped when it was dark, those sorts of things.
She doesn't talk, she sort of says that he vaguely talks about certain incidences, but she doesn't reference, and that's with respect to the beatings that he in fact regularly received from Honduran police when he was in the gangs, but she doesn't talk about the part in his affidavit where he says he observed MS-13 and the Honduran police harming greenlit gang defectors, and that's exactly who Mr. Ponce Flores is, and she ignores the risk that he faces because of that and his credible testimony to that effect. In addition, she ignores the testimony of his brother, which again in Alvarez Lagos and Portillo Flores was critical to consider this credible testimony about the neighborhoods, particularly in Alvarez Lagos, that how the police are reacting, right now to former gang members. So these are individual aspects of this case that the agency didn't really factor into her analysis and sort of ignored evidence that really would have allowed her to engage with these individualized facts. And another problem that happened in this case is, again, the legal error in failing to use the accurate definition of torture when she concluded, excuse me, that the Honduran government would not torture Mr. Ponce Flores. The regulatory definition of torture is much broader than the one that the agency used. She relied on sort of a colloquial definition that the expert, Dr. Gutierrez, used when asked the question, is Mr. Ponce Flores going to be tortured by the Honduran government? She responded, well, he's not going to be cut up and dismembered. And the agency referred to that definition a couple of times in her analysis and to conclude that in agreement with the expert that he would not be subject to torture because of that. And actually the expert in her testimony talks about the fact that while he wouldn't be cut up and dismembered, he certainly would be subject to beatings. You read the IJ quoting your expert's statement about, the police aren't going to cut him up, but they are going to, potentially look the other way if X, Y, or Z happens. You read the IJ's quotation of that to mean that the IJ was substituting that for the legal standard that she quotes on page 9 of her opinion, that no, torture is not certain physical or mental pain or suffering rising to a certain level, but instead it's being cut up. You think that's the actual holding of the IJ, and that she made a holding about torture, that wasn't in the discussion of acquiescence, but it was about the definition of torture. Yes, Your Honor. At 69, I will just read from the opinion. Again, Dr. Gutierrez testified that police would not cut the respondent up and torture him, and that is not what she has come across with Honduran police. The respondent's risk of torturous harm by police or other authorities in Honduras appears minimal. She engages and applies that definition over and over again and really relies on that testimony for that proposition. So I do think, Your Honor, that that is a definition that she was really relying upon to come to her conclusion. And she certainly didn't talk about the other expert testimony that he would be beaten by police, and in fact that he's already been beaten by police. And she didn't talk about the expert's affidavit, where she explicitly states that there would be no police protection for Mr. Ponce Flores specifically. She had that finding in her affidavit, and so there was.
IJ did talk about the expert at great length, and the expert's testimony, although helpful to you, was qualified at kind of every stage of her conclusions. They were qualified along the way, and I thought the IJ did a thorough job of going through everything the expert said. But on this torture point, the BIA didn't rule on that ground, right? The BIA declined to rule on the definition of torture holding because of its ruling on other grounds.
Well, yes. So and we think that they should have ruled on it, because what we're talking about is whether. The board decided, because there's been a finding that there will be torture in the aggregate, that it doesn't need to reach this issue of whether that torture will be by the Honduran government specifically. But that's what we're arguing, that the torture will be by the Honduran government, and that the agency really failed to consider both, applied an incorrect definition of torture, and also failed to consider in its analysis the actions of low-level police officers within that analysis, again, as required by the Attorney General, a matter of OFAS, and also by this court.
So can I ask, so how much, there's always going to be, I assume, some instances of low-level corruption, brutality in every government, ours included, frankly. So how much is too much? What's the standard?
Well, I think the question is, the question before this court, and the question I think generally in each case, because these cases are very fact-specific, is can and will the Honduran government protect Mr. Ponce Flores from torture? And we look at Mr. Ponce Flores in order to make that determination, and because of his individualized facts and also the situation in Honduras, particularly with respect to the level of corruption there, it is highly unlikely, we think it's likely that Mr. Ponce Flores will face torture by the Honduran government or with their acquiescence.
But is that actually the right question under the CAT? Isn't the question under the CAT first, how likely is the bad thing to happen? And second, if the bad thing happens, how likely is that because the government knowingly or with deliberate, if the government with a culpable state, so I don't know if the question is how likely is the government to stop it, it's how likely is it that the government will fail to stop it, and that failure represents some sort of acquiescence on the part of the government. Isn't that actually the right question?
Well, Your Honor, yes. I mean, so the first question is there willful blindness? And then the second question is, if you establish that there is willful blindness, and I think in this case that the IJ has assumed that, or the agency has assumed that, will there be a breach of has the government breached its legal duty to protect Mr. Ponce Flores, or rather, will they? And in order to make that determination, you need to both look at the individualized risk factors of Mr. Ponce Flores, and then you also need to consider what is the status of the government and what are they doing.
Wait, you said, where did the agency assume there would be willful blindness?
Well, she makes a finding that he's more likely than not going to face torture in the aggregate, and she includes.
Well, I think the fundamental challenge I have in all of these cases is that people use the word torture to mean two different things. They use torture to mean the bad thing happening to him, but that's not how the CAT uses the word torture. The way the CAT uses the word torture is it's not enough that the bad thing happens. The bad thing has to happen with the and sometimes people use the word torture when they mean only the first thing, and sometimes they use torture when they mean both of the things collectively. I agree with you, the IJ assumed the first part, that the bad thing is more likely to happen. But where's the evidence that they assumed it would be with the willful blindness or the acquiescence of the government?
Well, we disagree with her finding that it would be with the acquiescence of the government. She makes that finding, and she makes that finding because she is, one, ignoring a bunch of really legally relevant factors about Mr. Ponce Flores, but she also makes that finding because she determines that although there is some corruption, that the government has taken some steps, and that those steps have been successful to address that corruption. But when she does that, she cites to evidence that does not support that proposition at all. all of the efforts that she cites that the government has taken have all failed, and all of that failure is documented within the very documents that she cites for that proposition. And that brings me to my third point, which is that this IJ failed to meaningfully engage with evidence. And not only did she ignore Mr. Ponce Flores' affidavit, which he was deemed credible, his brother's affidavit, but also in her engagement of the evidence, it wasn't meaningful. This is a long decision. It is 14 pages long. Only 1/4 of it is legal analysis. Only 1/4 of it is legal analysis. And a few paragraphs of it is devoted to acquiescence. And in this whole discussion, I don't see a meaningful engagement with the evidence. In fact, I see a distorting of the evidence and an ignoring of the evidence, and a real attempt by this agency, although she cannot ignore the fact that he will face severe harm, to use the correct word in the analysis, if he's deported to Honduras. She goes out of her way to try to avoid the fact that that will be by the Honduran government or with its acquiescence.
Carl, your time has expired. You've got some time for rebuttal. Thank you very much.
Thank you.
Ms. Pratt?
Good morning, Your Honors. May it please the Court, Sharice Pratt for the respondent, Merrick Garland. This case is about findings of fact and whether the agency's findings of fact are supported by substantial evidence. The standard of review is highly deferential. The immigration judge thoroughly considered the record evidence. Beginning on page 57, she cited to his, on page 59, she cited to his testimony that he has the green light, that MS-13 wants to kill him. Notably, he never alleges that Kumba works with the police. So if we're looking at police acquiescence, even though he says that Kumba has given him the green light, never in his testimony, in his affidavit, in the expert's testimony, never do they allege that Kumba is working with the police. On page AR-61, he said that the immigration judge acknowledged that he fears the ex-military in Honduras, who are known as the Dark Shadows, who seek out current and former gang members and kill them. And she also acknowledges that he says that the police are corrupt, so he could not ask them for help. So she credits his testimony throughout. The IJ also cited his affidavit that he saw police kill people. This is on page AR-68. And she notes that he does not provide context for the incidents. Moving on to page AR-69, she cites extensively to the police, to the reports in the record. Exhibits V, X, Z. I'll just go through them. His affidavit at Exhibit N, pages AR 710 to 721. The psych evaluation, Exhibit X, AR 817, the expert affidavit of Dr. Eric Hirschberg. The United Nations High Commission on Refugee report at Exhibit, page AR 890, 891. The International Crisis Group at page AR 1031, the U.S. State Department Human Rights Report at AR 1052, 1054, and it just goes on. That's all on page AR 69.
Can I ask you a hypothetical that I think illustrates the, so I mentioned to your friend on the other side that the dilemma I have when people use the word torture to mean two different things. I think another problem I think I have in this case is what the government means. So can I give you a hypothetical that I think will help identify what is bothering me a little bit about this case? So imagine a world in which a single rogue police officer, but he's acting as a police officer, he's wearing his police uniform, he's at the police station, a single rogue police officer takes someone and delivers them up to MS-13 to be tortured and killed. And to be clear, when he does that, he is violating orders, he's violating the chain of command. The government, his chief prefers that he not do that. The government prefers that he not do that. The government has taken steps to root this corruption out, but he's the deeply embedded MS-13 agent that they've just missed. But he's wearing a police uniform, he's acting as a police officer. When that person is tortured and killed, that is within the meaning of the regulation with the acquiescence of the Honduran government, correct?
Yes, that sounds like it would be.
Okay, and so the reason I say that is the mismatch I sort of perceive is I see the IJ, I see the agency, and I see the government in your brief saying, look, the Honduran government is doing the best they can to root out these bad apples, and that's commendable, and they should do that. But the fact is, if at the end of the day it is more likely than not that an individual rogue officer is likely to do what I just described, that would still be with the acquiescence of the government, right? No matter how hard the government tries to root it out.
But the expert testified it's only a minority of.
Oh, no, I agree with you, just as a conceptual matter, right? In other words, if I present evidence that an individual officer is likely to do something bad to me, and the government presents evidence that says, the federal government, presents evidence that says the Honduran government is doing the best they can in a truly, really hard situation, those two things are sort of talking past each other, right, within the language of the cat. Because in the language of the cat, it doesn't matter how hard the central government is trying. It matters what's more likely than not in the world as it exists now.
That's the bottom line.
Okay.
Is it more likely than not that the Honduran government would acquiesce to?
No, but see this, now you've just reintroduced the Honduran government. Is it more likely than not that any individual person acting in government authority, right?
Would acquiesce to his torture. So 50% or more likely than not that any individual acting in government would acquiesce to his torture. The expert said no. The expert said there are a minority of corrupt officials and that when they're discovered, they are fired, arrested, prosecuted, and rooted out. And the immigration judge cited extensively to the reports detailing the large amount of gang members and the amount of police versus the small amount of the corrupt officials.
So where's the cleanest point in the record where the IJ says that? The IJ says, I understand that it's not enough that the central government is trying to address this problem. I understand that it's not enough. They've fired a lot of bad officers. I understand the ultimate question is whether, as applied to this individual, it is not more likely than not that an individual rogue officer would acquiesce in his harm. What's the closest the IJ comes to saying that?
I think it's on page AR 70, where the immigration judge she addresses the police turning in the MS-13. She says that she specifically refers to the reports of corrupt police cooperating with gangs, including reports of Honduran authorities accepting payments from gangs in exchange for conceding authority or participating in criminal activity themselves. And she finds that reports in the record do indicate generally that impunity is widespread, that security forces are frequently in cahoots with gangs. So the IJ does not ignore that evidence. The IJ considered the evidence.
No, I understand she doesn't ignore it, but where does she make the finding? Not because that evidence actually sounds good for him and bad for you. Where does she say?
Because then she defers to the expert who said that they actually, even though these country conditions reports, say that, the expert said it's actually in her testimony on pages 141 and 140 to 141 of the administrative record and on 151 that it's only a minority, and she reiterated it.
But I guess the response to that is what your friend on their side says. Even if it's only a minority, from his perspective, it only needs to be one. It doesn't have to be 1,000
From the law's
bad.
perspective, it needs to be 50% or greater likely.
Well, no, but from the law's perspective, it doesn't have to be that a majority of officers are bad officers. It has to be more likely than not that something bad will happen to this individual. And honestly, if
With government's acquiescence.
I guess what I'll say is if every single police department had 100 officers, only 2 of whom were bad, but those 2 would unerringly hunt down someone like him, it doesn't matter that 98% of the officers are good. And what matters is it more likely than not that something bad would happen to him as a result of the conduct of an officer. And where does the IJ say she considered that possibility and concluded that it's not more likely than not?
And I believe that she says that on page AR 70.
Okay, where? I see her talking about the government has fired a lot of bad officers, which again is commendable.
71. She says, to be sure, he faces a clear probability of being severely harmed and does face a risk of severe harm with the consent or acquiescence of the government. Still, what did she say? that police would probably meaningfully respond in some form, even if there is a chance that they would not. And even if there's a chance.
But it doesn't
that
matter
would
if they
not be
respond. It
successful.
matters if the bad thing ends up happening or not, right? And so, well, okay, so
And then the final paragraph, she says, considering all evidence presented, the record does not establish that any minimal risk of severe harm to the respondent by authorities, coupled with any risk of severe harm to him occurring with the consent or acquiescence of the government, would equate with a clear probability of torture level harm. So speculations are not enough that, oh, what if he runs into a lone corrupt officer? It has to be more likely than not. So if you have no further questions, I would rest on the briefs and the 28J letters.
All right, thank you, Ms. Pratt.
Thank you.
Ms. Carl?
Thank you, Your Honors. My friend referenced what she believed to be represented a meaningful engagement with the evidence, but really the parts of the opinion that she was referring to are the 14 pages that, or I'm sorry, the 3/4 pages that basically just engage in a summary of the evidence, listing the evidence. And this court has held that there has to be meaningful engagement with the evidence. And barring meaningful engagement with the evidence, the court has to provide, the agency has to provide cogent reasons for why they did not engage with the evidence. And here the IJ has disregarded and or mischaracterized evidence in her analysis, which is the last quarter of the decision.
Can I ask you to respond to Judge Hyten's hypothetical? And let's assume instead of 100, it's a 10,000 member police force, and there are, I don't know, 10 absolutely corrupt, vicious, violent gang members in hiding in that police force.
How many did you say, 10?
10, let's say 10,
10.
2, whatever the number is, but a very small minority. But, that alone wouldn't be enough, right? You would need to tie your clients, your petitioner's situation to those 10 officers, to however many they are, and show a likelihood that those 10 officers would in fact do harm, the kind of harm that amounts to torture under the statute.
I don't think the number matters, Your Honor. I think the impact of the corruption of those members matters. And so what is the power, what is the ability of those members? And as you were saying also, Your Honor, what is their engagement with or their likelihood of them engaging with and harming Mr. Ponce Flores, which is why it's so important, which is why a matter of OFAS asked this court to consider the actions of low-level officials, which the court didn't do in this case, and which I think is on its own a basis for remand to ask her to consider what the actions of the low-level officials would be.
Push back on the idea that the number doesn't matter at all. If it were 99% of the police force is in the pocket of the gangs, that would seem to make it really help a case that it's more likely than not that anyone who is opposing the gangs is going to be caught up by the police, right? But if it's a very small number, it doesn't prove, you have to show the personal connection, right? That there's some reason to think that this person is going to fall into the hands of one of these corrupt officers.
And also, what is this person's particular risk factors? And in this case, you have a green-lit gang defector who's going to be transferred from U.S. custody to Honduran custody with this record that exposes him along with all of his tattoos. So you have to factor all of that into then the analysis involving the low-level officials and what the likelihood is that they're going to torture him directly or acquiesce to that torture. The agency spends a lot of time talking about majority versus minority, borrowing the language of the expert, but I wanted to point out that a minority could still constitute 49%. So I think this getting into the numbers is less helpful. There have been other circuits that have held that the acquiescence standard, that the agency really needs to provide clarity on the acquiescence standard. The First Circuit recently in HHV Garland, and then also the Second Circuit in Garcia Aranda, they have all asked the agency to provide clarity on what it means for a government to breach its legal duty to protect someone from torture. I do think that in this case, the agency had sufficient guidance to make the decision here because she failed to look at the actions of the low-level police officers and because of the other failings of...
To be fair, we've put an obligation on the agency in these cases to add up percentages, right? We don't require them to pin arbitrary numbers, but we've suggested you've got to show that you've considered all of them, added them together, and it still is not more likely than not. And the IJ tried to do that, and I think also acknowledged these numbers can't tell the whole story about an individual person, even though, she went through the numbers analysis. It does seem, I mean, this analysis on page 71 talks about, things that are particular to him as a individual who avers he's no longer affiliated with a gang. So there's both in there in the IJ's opinion.
Respectfully, Your Honor, I think she doesn't consider in her legal analysis the fact that he's greenlit a gang defector.
You want me to look at just part of the opinion. You keep coming back to only look at what I'm calling the legal analysis, which is this certain page. But as you noted, the opinion's 16 pages long, and this is the only conclusion of the entire opinion is this acquiescence conclusion. So that's the basis for the ruling. So why shouldn't I read the whole opinion?
Oh, Your Honor, you should absolutely read the whole opinion, and I think in doing so, it becomes clear that, she's listing a lot of evidence, and in her analysis, she does engage to some extent, but she cherry picks, mischaracterizes, and distorts the evidence in the process of doing that, and she disregards critical facts when she comes to her conclusions. And that's something we would ask the court to look at very seriously, her engagement with the evidence. And in addition to that, also the fact that she uses the incorrect definition of torture in her analysis, borrowing from this colloquial definition of torture. And then finally, on the acquiescence standard, the failure to consider the individual facts in this case that are so critical. And this court acknowledged the importance of considering credible evidence from the petitioner in Alvarez Lagos and Portillo Flores because they're so critical to assessing, to understanding in these highly fact-specific cases whether there's going to be a risk of harm. This court has held that no two cat claims are the same, that two people facing deportation at the same time to the same country, one might merit deferral under the Convention of the Torture, and another might not. And in this case, Your Honors, there's no question that Mr. Ponce Flores merits deferral under the Convention Against Torture because of who he is, a greenlit gang defector who was recently stabbed by MS-13. Who is going to be transferred from U.S. custody to Honduran custody with the document proclaiming his gang membership or prior gang membership and the tattoos that he bears. There's no question that he's going to be tortured by the Honduran government or with their acquiescence. Thank you.
Thank you very much. Thank both counsel for their arguments, and we would typically come down and greet you, but we can't do that today, but nonetheless, know that we very much appreciate your being here today. Thank you. We're going to move on to our final. Mr. Grunrod, whenever you're ready.
May it please the court. When Mr. Castellano admitted violations, the district court revoked his term of supervised release, sent him to prison, and imposed a new term of supervised release following revocation. A special condition governing that new term forbids Mr. Castellano from looking at pornography or even artistic depictions of adult nudity. We objected to that forward-looking condition. In the district court, the government responded on the merits. Today,
threshold question. You just said imposed a new term of supervised release. Didn't he already have a life term?
Well, Your Honor, the district court revoked the then existing term of supervised release and sent him to prison for the maximum revocation term. And I think the best way of reading 3583 is that the term imposed under 3583H is a new term of supervised release. And I think the statute gives us strong evidence of that. And so I would direct you first to 3583H itself. The language of 3583H says that the court may require that, quote, the defendant be placed on a term of supervised release after imprisonment. Obviously, place is a transitive verb. It's talking about putting the defendant in a particular state or condition. Congress did not say that the defendant should simply be continued on a previously existing term of supervised release, but that he be placed on it. We have another statutory hint that this is a new term when you compare that language that I just quoted to Section 3583A. It uses the same language. So when a court is imposing supervised release in the first instance, it says that the court may include as part of the sentence a requirement that the defendant be placed on a term of supervised release after imprisonment. So that's textual clues that what the court is doing here is the same thing. It's placing a defendant on a term of supervised release. But there's more statutory text that supports our position on this front. If you look at 3583H's second sentence, it seems to refer to two different terms of supervised release. So it refers to such a term of supervised release when it's referring to the new term, the term that's imposed following revocation, and it contrasts it with the original term of supervised release. So again, statutory text suggesting that these are distinct terms and not some unified term. And then we have the overall structure of 3583, which I think supports this conclusion in three different ways from a structural standpoint. So one, we have basically three different rules that will govern a 3583H post-revocation supervised release period than the original term. So we could have a new statutory maximum term of supervised release. We could have a different mandatory minimum term of supervised release. And we could have a different ultimate sunset date for the term of supervised release. So with respect to the statutory maximum, that comes from 3583H's aggregation rule. When someone is originally placed on a term of supervised release and then they have that supervised release revoked, however many times they have it revoked, that total amount of time that they spend in prison on revocations has to be subtracted from the statutory maximum term of supervised release. So when the court is putting someone on supervised release under 3583H, it's dealing with a different maximum term of supervised release, at least in most cases, not when the term is life, than in other cases. With respect to the new mandatory minimum, this court's decision in Nelson clarifies that a mandatory minimum term of supervised release that might apply, for example, under 3583K for certain sex offenses, does not apply upon a 3583H new term of supervised release. And then finally, we have a later sunset date. And so this is a function of post-revocation supervised release essentially kicking out the ultimate end date of supervised release. If someone is revoked on their last day of supervised release and they're sent to prison for a day, the court could then impose under 3583H a new term of supervised release that it was whatever the statutory maximum was before minus a day. And so if the maximum had been 3 years or 5 years, all of a sudden that person's sunset date is 3 or 5 years further out than it would have been if their supervised release hadn't been revoked. So that's a long way of answering your question, Judge, but I think there's all kinds of evidence in the statute, whether it's the text or structure, that shows that the court is doing something new here. And that is how this court talks about 3583H in other contexts. Most recently, the Nelson decision that we submitted a 28J letter on uses that same language, a new term of supervised release. I wouldn't necessarily hang my hat on kind of casual references like that, but I think the court is looking at that, and the text and the structure, they all lead to that same conclusion.
But we also recognize, right, that the reason the district court can impose a sentence upon revocation, the authority for that comes from the original violation, right? That the revocation sentence and the supervised release that follows is part of the original sentence, right? You just noted the time limitations and things. Those are all triggered by the original conviction, right?
Yes, I don't dispute that at some level, the whole basis for a supervised release here relates back to the original conviction. But I think that's a separate question from whether what the court is doing here is something new. It's a new deprivation of liberty when the person is sent to prison.
Arguably, it goes to whether a vagueness or overbreadth sort of facial challenge to a condition that was imposed originally, whether that has to be raised in the first instance when the condition is first imposed, or if you can raise it again every time supervised release is revoked and then reimposed in a new sense. So this idea that the every revocation sentence ties back to the original sentence. There's some connection between that and the idea that if you have an objection to these conditions, you make it when they're imposed originally. You don't get a second, third, fourth bite at the apple every time you violate your conditions of supervised release. Unless you're making an as-applied challenge, maybe, right? I shouldn't be sent back to prison for this violation because, it doesn't apply here or something like that. Or circumstances have changed, modification.
Your Honor, I understand the conceptual argument. I think it doesn't really fit well in the doctrine, though, and I don't think the government really explained how this fits in existing doctrine or how it should fit in the doctrine, because the government just cites Johnson and says, well, Johnson's binding precedent on this point. Johnson is clearly not binding precedent on this point. The whole notion of post-revocation supervised release was not even litigated in Johnson. So the government can cite Johnson if it wants to ask for Johnson to be extended into a different context, if it wants a new rule that should be applied in this context, but Johnson doesn't get it.
Problem? Do you think there's a problem with allowing someone who repeatedly violates their supervised release to have more chances to challenge their original conditions than someone who's abiding by their supervised release conditions?
Well, Your Honor, I don't think that that's the way that the rule is going to cash out, and certainly not in all cases, and perhaps not even in most. But what the government's asking for is something more extreme than even a rule like that. I mean, what the government is saying is not that the same standard as 3583E2 motions and the same standard that this court applied in that context in a case like McLeod should apply here. I mean, the government is saying
that captures what my concern practically about your position is. So imagine a defendant is placed on 2 conditions of supervised release, 1 and 2. He does not appeal the validity of either of those 2 at the time. Years pass, and he gets violated for violating condition 1. And let's concede 1 is completely constitutional. 1 is the most plain vanilla supervised release term in the world. So he gets violated for violating condition 1. He gets sent back to prison, and the district court reimposes conditions 1 and 2. And he says, oh, well, while we're here, I have a real problem with 2. And I know I didn't raise that ever at the time. And so that's the hypo. Or imagine that he violates condition 1 over and over and over again. And after violating condition 1 the 10th time, he says, I have a real problem with 2. For the very first time. He's never once said he has a problem with 2 until now. That defendant is now better off than the defendant who, when he does violate 2, tries to defend on the ground that 2 is invalid. And under Johnson, he can't do that, right? He's not allowed to do that under Johnson. Why does that make sense?
Your Honor, I don't think he's better off because
he gets to make a challenge that the other person who hasn't violated condition 1 10 times doesn't get to make.
Well, but unless I'm misunderstanding the hypo, Your Honor, Johnson would only forbid him from defending against a violation for that second condition. And so sure. I would agree with you, Your Honor, that if a defendant in a case like that waited until he was being revoked for a violation of condition 2, that then he could only raise an as-applied challenge. But the question is whether, as a forward-looking condition to govern his conduct going forward, he can timely object at the time that the judgment revoking his prior term of supervised release and imposing a new term is imposed.
Why don't, I guess so why don't just basic principles of forfeiture, I mean, I don't think this is jurisdictional, I think it's just forfeiture, but why don't basic principles of forfeiture say, you got condition 2, you didn't object at the time, you were revoked condition 2. Like at some point, why don't basic principles of forfeiture entitle the district court to say, why in the world am I hearing about this problem for the first time now that, according to you, existed from the very first time I imposed supervised release 12 years ago?
Well, I think in this case, it's an easy answer, is that the government waived this argument by not raising it in the district court. And so if they're going to proceed, if they're going to say that this is based in waiver, forfeiture, something like that, then they had to raise this in the district court. They can't raise it for the first time in a response brief on appeal. And I think that 2255 is an analogous context when you look at cases like Metzger that say government's failure to raise a waiver issue is itself a waiver of the waiver. But I think when the court's thinking about this in other cases, I still think it's not going to make a ton of sense to think of it as forfeiture. I think you would have to go further and say that this is something like issue preclusion. But forfeiture...
Well, more claim preclusion, right? Because the argument is that you had this argument available to you when you were but you didn't press it. I mean, that's what claim preclusion is, right?
Well, but it's not the same
I don't think it's the same claim, Your Honor, because it's a different time. I mean, it's a new term of supervised release, and so I think that I think you'd have to go further than claim preclusion, Your Honor. But I think at the very least, what makes the only way that the government's rule here would affect cases would be to create an anomaly in the doctrine going the other way. And this goes back to the point you were making, Judge Rushing. I think that if you're worried about situations in which someone would challenge a condition and have a windfall because of a violation, the answer would be to look to the standard in McLeod and to say, well, if there's a change in the facts or the law, we would allow someone who hasn't been violated to come in here and challenge a condition.
So you have an alternative argument for modification, right? That we asked to modify this condition, and the district court denied modification, right? A different way to conceptualize the challenge.
Yes, Your Honor. And I mean, I think we would, if that were the standard, we would win on that standard. I don't think that's the correct standard from a doctrinal standpoint, and I would urge the court to look at this as a new judgment. I mean, this is what the court is doing here is it's revoking supervised release and it's imposing a new sentence. And in many ways, Judge, you're right that relates back in some way at least to the original judgment, but it doesn't just flow directly from the original judgment. I mean, imagine a situation in which the court simply revoked supervised release, sent Mr. Castellano to prison, and then remained silent. I mean, I don't think anyone would say that the supervised release term had continued past the revocation, the conclusion of his imprisonment on revocation. I mean, the court is doing something new here. This court's cases acknowledge that the court is doing something new, and when the court imposes a sentence on the revocation, so much of that sentencing process is bound up in discretionary, traditional sentencing determinations. How long to send the person to prison for, but also how long should the court put them on supervised release or not? I mean, that's a highly discretionary decision. This court's decision in Nelson says, yes, the court has full discretion. Should I put them on supervision or not? It would sort of break apart that whole unified analysis to say that the decision of whether to put the person back on supervised release gets reviewed. How long the person is placed back on supervised release gets traditional review. But then the conditions that are going to govern this new term of supervised release that is only existing because the court made the discretionary choice to impose a new term under 3583H, we're going to insulate from any review those conditions. I don't think that there's a doctrinal basis to do that. And the government certainly hasn't brought one out here. I mean, I think that as Judge Heitens was saying, that the easiest way to resolve this issue in this case is to say it's not jurisdictional. Clearly, this does not go to the subject matter jurisdiction of the court. Whatever Johnson might have said about jurisdiction, that was citing a federal rule of appellate procedure that this court has subsequently said is a non-jurisdictional claims processing rule. In the mid-2000s, the Supreme Court said, no, we're going to be much more careful about when we talk about things that are jurisdictional versus non-jurisdictional. This is not a jurisdictional argument. The government waived it. And then perhaps the government in a future case could brief this and raise these arguments in the proper forum so that this court can be a court of review instead of first view on this issue. But we would ask the court to consider these for abuse of discretion review. And I think that with respect to that, Your Honor, there is precedent on this matter. If you look at Ellis reviewed a pornography ban that had been imposed before. And this is clear on page 1097 of the opinion in that case. The district court had imposed the pornography ban earlier. There was a revocation. The pornography ban was reimposed, and then this court reviewed that ban for abuse of discretion, and it struck the ban down. The other thing, when it goes to the merits, I think Ellis says a lot about this case. My friend says, well, this case is different because Mr. Castellano admitted a pornography addiction. But Mr. Ellis had two. Judge Quattlebaum wrote in his concurrence in Ellis, quote, Ellis admitted a serious pornography and sex addiction. And yet, notwithstanding Ellis's admitted addiction to pornography, this court struck down that pornography ban because no individualized evidence tied the ban on legal pornography to Ellis's rehabilitation or recidivism. And so we would ask the court to do the same here. Your Honor, I'll reserve the balance of my time for rebuttal.
Thank you very much. Mr. Grano Mickelson, we'll hear from you.
Your Honor.
Good morning, Your Honors. May it please the Court, Aidan Grano Mickelson for the United States. I'll start with the Johnson issue. I think where my friend on the other side and I agree is that this rule is not jurisdictional. It is not subject matter jurisdiction. It is a rule that this court adopted predicated on Federal Rule 4 and the timeliness of appeals, which, as my friend agrees, is also a mandatory claims processing rule as this court held in Marsh. What is less clear, and I think has not been supported by any of the cases, is whether or not it has to be asserted in the district court to be preserved. Because it's grounded in Rule 4 about the timeliness of an appeal, Johnson appeared to treat the issue as being an untimely appealed issue, and the remedy for that is typically dismissal of the appeal. So I don't know that it's been characterized as an affirmative defense as procedural default has in 2255, which is what Metzger is talking about. So the court has a plethora of cases talking about how procedural default is an affirmative defense that needs to be pleaded in the government's response to the 2255 motion. That case law is absent with respect to the Johnson rule. Johnson merely says that an appeal from a revocation order does not suffice to challenge special conditions of supervised release that were imposed in the original judgment. Now, I also agree with my friend that Johnson is not entirely on all fours because the conditions were not reimposed. But neither is Holman, which my friend relied on in his briefing, which was the opposite version of a new condition that was added that was not in the original judgment. So I think this case is addressing a slightly different permutation on both cases. And where I think the government's argument comes out ahead is when we look to Sanchez and McLeod. As Judge Rushing pointed out, this court has held that a defendant cannot move to modify his conditions of supervised release unless new legal or factual circumstances have made that argument available where it wasn't available beforehand. As Judge Hayton's pointed out, that then puts the individual who violates his supervised release 10 times in a far better advantageous procedural position than a defendant who complies but wants to get out of the condition on the basis of a facial challenge 10 years later.
Can I go back to the question of when the Johnson claims processing rule has to be raised? So it strikes me that this is, like any other forfeiture rule, a matter of sort of managing litigation in a way that makes sense and is efficient and yada, 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 right? So the question is, when I have a problem with Condition 9 and I don't want Condition 9 reimposed, I mean, it seems to me that pretty much every principle of judicial administration says that at that point the government should say, whoa, 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 untimely forfeited judge, don't consider that argument. He should have raised this the first time and he didn't, right?
I agree, Your Honor. I think the optimal best practice this time is that it be asserted in the district court. I don't think it's been held that this is the kind of defense that needs to be asserted in the district court, or it's been waived.
But like any other claim processing rule, the rules about when you have to present it are determined in part by whether the purposes of the rule suggest it should be raised at time X or time. Well, I guess the first question is it possible? So let me ask you this again to make implicit something that I think is, to make explicit something I think is implicit. Imagine that when the district court revoked him and then imposed whatever the district court did, the district court said, you still have to comply with 1 and 2, but now I'm adding 3. You certainly agree that Johnson doesn't say he can't appeal 3 at that point because 3 was never imposed before that point. This is his first chance to challenge 3, right?
Yes, I agree, Your Honor.
Okay. And so, okay. Because in part I could imagine, I guess the reason I raised this, I could imagine a dispute where the defendant, so now the government agrees that the defendant can challenge new conditions, but he can't challenge old conditions. I guess I could imagine a case where the parties are disagreeing about whether this is really a new condition or not, right? Where the government says, but this is exactly the same condition as you had before, and you should have raised it at the time of the first hearing. And the defendant says, well, sure, but there's like a bunch of intervening Supreme Court authority that I couldn't make this claim before because the Supreme Court had suggested, there's lots of reasons why the defendant would say, this isn't really the same. I know I didn't raise this claim before now, but I have a good reason. And I could imagine a dispute between the government and the defendant about whether this is a claim that really should have been raised before. And wouldn't it be a lot better if we'd adjudicated that in the district court rather than for the first time on appeal?
Your Honor, I again agree. I think it's better adjudicated in the district court, but I would point out to the court that it would be an extension of Johnson for us to have argued that those arguments were barred in the district court, because Johnson doesn't say that. Johnson talks about an appeal. So we would have been asserting essentially an extension of Johnson, maybe saying the same rule from McLeod should apply with revocation proceedings, but there isn't actually precedent that says that. So I agree. Best practices would be raised, and believe me, I will talk to my AUSAs about this and give the presentation on raising this defense. But I would also point out that if we're talking about the interests of judicial efficiency and administration, Metzger actually talks about the exception to the exception to the exception, which is when the rule concerns judicial economy or efficiency, the court will sometimes waive the government's waiver because it's more efficient to deal with this, to deal with settled issues or settled issues. So even if we're in the Metzger universe of we've waived something that is an affirmative defense below, the exception in Metzger applies to this rule, because this rule is grounded, as Sanchez points out, in the idea that we don't want to duplicate original proceedings every single time there's a revocation of supervised release. As Sanchez points out, judges would be required to rehash issues in largely duplicative proceedings. And Sanchez then relies on the very unjust point about individuals who revoke, who violate their supervised release and have that supervised release
Can I
revoked.
ask a question about, so Judge Hyten's in the hypothetical that he presented to you. You had 3 conditions, a new condition, 2 pre-existing conditions, which the district court, and he said, reimposed. You know, by definition, the district court is not required to adhere to those 2 original conditions. And that's the whole premise of your friend's argument on the other side, is that the district court, at that point, why couldn't he revisit the imposition of conditions 1 and 2, precisely because we're dealing with an entirely new judgment?
Your Honor, I think if the district court, in looking at the record, said, I no longer think these old supervised release conditions are appropriate or they don't fit the defendant's state now, things like that, he absolutely could.
Why couldn't a party do that?
Because again, I think the Johnson rule and this application of the Johnson rule in the district court has to do with whether or not the district court is required to consider those arguments and take them into account. The defendant, if he challenges conditions that were imposed in the original sentencing, there'd be nothing wrong with the district court saying, those were appropriate then and I think they're appropriate now, and that's kind of the end of the discussion.
Your answer moved to language of modification, right? The district court saying, well, these aren't appropriate anymore. Is the government saying a defendant can't bring that sort of challenge? I mean, couldn't a defendant always go to the district court and say, this, you know, regardless of whether condition 2 was appropriate when I was originally sentenced, I don't think it fits still today, please modify it?
So that's the McLeod exception, I would say, Your Honor, is if when there are changed legal or factual circumstances that for some reason a condition originally imposed is no longer appropriate, or a defendant wants to argue that it's no longer appropriate, that's the door McLeod says.
Right. But to answer Judge Diaz's question, could a district court, I mean, a district court has all sorts of discretion, right? Couldn't the district court say, condition 2 was constitutional when I imposed it, but there's been new law and I'm reconsidering and I don't think I'm going to impose it anymore because it's of questionable validity. Nothing's changed with the defendant, but the intervening law has changed and I no longer have confidence in number 2.
I just want to make sure I'm understanding your question.
The district court can do that.
The district court can absolutely do that. The district court has broad discretion with setting conditions of supervised release. It could simply decide, I don't like this condition anymore. I imposed it 10 years ago and I haven't seen it be effective in my other cases. I'm taking it out now. I think the district court has the discretion to do that. I think what we're talking about is whether the defendant can raise arguments that were available to him at an original sentencing in a revocation proceeding about whether those conditions should continue going forward.
Do you think the law has changed in a way that a defendant could raise that argument? The defendant could say, look, the law is different than when I was originally sentenced, so this special condition 9 is no longer valid, you shouldn't impose it. Does that allow us to review that question in this case?
Your Honor, I think at this point it sort of gets to your point about this is kind of a modification and a revocation mashed together, and McLeod says you can ask for modification on that basis. And so I think it would be sort of empty formalism if we were to say you can't raise those arguments in the revocation proceeding, but the day after you can file a motion to modify those conditions to say because on the basis of new law that McLeod leaves open. So I see no practical value in that rule of not permitting arguments that are based on new facts or law to be raised in the context of a revocation proceeding. I think the line is sort of the same as McLeod.
Do you think there's new law here? Do you think the door was open to a modification here because the law changed in such a way that, there could be grounds for a modification?
I do not. This court has held, I believe in the case Morris just recently, that Packingham, Ellis, and I believe Hamilton is the third one, Hamilton, changed the legal landscape about total internet bans such that individuals could move under McLeod for modification of those bans. But defendant didn't actually challenge his ban on computer devices that can access the internet in the district court or on appeal. The conditions here relate to merely the limitation on adult pornography, pictures displaying nudity in the magazines involving juveniles. The law has not changed with respect to those, and in fact, the law that the defendant and the court applied in this case is the same law that's found in the statute, that it be reasonably related to the purposes of supervision, that there be an individualized basis for it to be found for the defendant. And so,
what about the turning to the merits, what about the overbreadth argument, which I will confess to finding myself a little troubled by, because I have a term that is shockingly broad in its language. And then what I see a district court saying is, well, I don't think it covers this thing that its language seems to cover because. Can a district court narrow the terms? So that if the terms of supervised release say one thing, and that one thing is pretty friggin' broad, can the district court get rid of the constitutional challenge by just asserting that it doesn't cover something that the language seems to cover?
I think so, Your Honor, because the district court is the decider of what the supervised release condition is. This isn't a mandatory condition of supervised release that's found in a statute. This is a special condition that the district court imposes. So if the defendant says,
But the court speaks through the order, and the order is the terms of supervised release, not what the district court later claims to have meant by the words they use, right?
I don't know that I would agree with that, Your Honor. If a district court issues a subsequent order after briefing and argument by the parties that says this condition of supervised release means X, I think that order is just modifying, if you want to call it that, the condition of supervised release to mean what it says in the order, clarifying it. So,
this is some real due process notice implications problems that what a term of supervised release means is not what it says, but what the district court later says that it meant to say instead.
I think if it had gone the other way, if the language had been narrow and the district court had broadened it in a subsequent order, then the defendant would have an as-applied vagueness or overbreadth challenge in that context. And that's the door that even our proposed rule leaves open for as-applied challenges, as this court pointed out in Van Donk. So I don't think there are any due process or notice concerns where the language of the special condition is narrowed, particularly where it was narrowed on the defendant's request after briefing and argument in a revocation hearing. So I could see there being a problem if it goes in the other direction, but I don't think in this context.
You talked about that the law being fixed and there was no change to the legal landscape that warranted a modification. But we talked earlier about Ellis, and of course Van Donk set forth a pretty straightforward rule about the imposition of legal pornography and the requirements for doing that. Why isn't that enough to warrant the district court and or the party to assert a change in the legal landscape warranting modification?
Your Honor, I assume if we're using the same standard as McLeod about what a new or legal factual development means in this context, it can't be the case that anytime an opinion is issued on the subject, that's a new legal circumstance, because that deprives McLeod of all sort of sense and meaning. So I think it has to be something that's a sea change or a landscape change or a Supreme Court decision that reverses prior precedent or a novel issue that's never been decided before. But Van Donk, while talking about a pornography ban, applied the statutory language, applied normal principles about whether or not the special condition had to be related to the offense. So Van Donk may have been discussing this issue in detail, but I don't think it's a new legal development in the sense that McLeod and the rule we would be asking for here would be. It wasn't a sea change. It upheld the pornography ban. It didn't strike one down, you know, calling into question how they've been applied in the past. And I don't think Ellis is a good example either, because Ellis is extremely factually distinguishable from this case. The defendant in that case, his crime was not remotely internet related. It had nothing to do with computers or computer crime. And the internet ban involved there had obviously then had no relationship to his offense conduct. It also included extremely broad locational restrictions, that the defendant couldn't be anywhere where materials containing sexually explicit conduct could be located, like libraries. This is just not that case. I don't think...
Can I ask you about how far the door opens? Let's assume the change in the law door opens, contrary to, this is not your position, right? But assume that modification door opens. Is the opening only to the extent of the new law? So in Van Donk and Ellis are talking about legal pornography, but here we have a challenge to a condition that prohibits legal pornography in addition to maybe, you know, magazines with fully clothed juveniles in them. Can we consider, even if we think the door is open under Van Donk and Ellis, can we consider a challenge to that second part that has nothing to do with pornography, but just pictures of juveniles? Or is kind of the whole condition fair game? Do you have thoughts on that?
I have several thoughts in multiple directions, Your Honor. I think that's a very hard question. I think it's something that this court does when it analyzes whether one of its prior precedents has been called into question by a Supreme Court decision. That line is always fuzzy. It's always fuzzy between, if it didn't overrule us entirely, for example, did it still undermine the premises enough that we don't think this condition is no longer good? I think as long as the gravamen of the defendant's argument is this change in the law that is a new legal development makes this condition inappropriate, impermissible, unconstitutional for some reason, that's the claim that can be evaluated. And the district court is in the position, I think, of assessing the interpretation of the law and precedent and changes in the law, and then applying the condition that it thinks appropriate. And then I think this court can review that. So, you know, I don't think if the law changes as to special condition 1, you can appeal special condition 9, which is totally unrelated. But I think a subpart of section 1, if you've got an argument that the legal development changes the way that component of the special condition should be viewed, then I think that's probably a valid argument.
Can I ask another Johnson-related question? So how far does this argument go? Let's assume you've got a defendant who commits a crime, put on supervised release, 3 conditions, satisfies those conditions, doesn't object to any of them. A year later, he's convicted again of the same offense, same conditions imposed. Can the government make an argument at that point, and the same conditions, can the government make an argument at that point that those conditions, that he's waived any objection to the conditions by not objecting to them in the first proceeding?
Your Honor, in this situation, has his term of supervised release on the first terminated?
Yes.
So that's a great question that I haven't thought about. I don't think so. I think this is, if we...
Yeah, I don't see the difference. I mean, it just, if I claim preclusion, it would seem to me that the government has an argument that he didn't object the first time around, and you stuck with it.
I think
and assuming
generally...
no change in legal circumstances, the law is static, everything remains the same.
Generally, Your Honor, I don't think we invoke principles of sort of offensive collateral estoppel in criminal prosecution, and I think this would be sort of collateral estoppel from a different proceeding. That's different than waiver of an argument in an extant proceeding. That's not estoppel, it's not collateral estoppel, it's not importing the results of one proceeding into a second one.
Your friend's argument is that it really isn't an extant proceeding, it's an entirely new one because the condition has been reimposed as a result of revocation.
Yes, Your Honor, and my view on that is the point that Judge Rushing brought up. It is well established that supervised release is a component of a sentence that is imposed for an offense, and it is the same sentence all the way through. The defendant is not being given new sentences every time supervised release is revoked. Supervised release is a package that includes the potential for revocation, incarceration, and then further supervised release after it. That's the same statutorily authorized, bucket of statutory tools. I don't think there are new sentences being imposed subsequently. I think there would be serious constitutional problems with that. It has always been understood that supervised release is sort of its own unitary component of a sentence, and I don't think there's a basis to conclude that new sentences are being imposed each time a sentence is revoked.
All right.
Thank you.
Thank you. You have some rebuttal?
Thank you, Your Honor. I have 6 points. We'll see if I get to them. Your Honor, my friend noted that at the revocation hearing, the judge has broad discretion in setting the conditions that will govern a new term of supervised release going forward. But my friend's position is that despite the district court having broad discretion to revisit previously imposed conditions and reevaluate them on its own terms, that discretion is fully insulated from any appellate review. The doctrinal move that my friend makes is to say that, well, this all ties back to the original judgment. But I think that proves too much because, of course, this court is going to review the length of a revocation sentence and the length of the supervision tail for abuse of discretion review or plain error, or whether the sentence is plainly unreasonable. And so just tying any component of a supervised release revocation sentence to the original term doesn't insulate any other aspect of that sentence from appellate review. The other thing, with respect to the practical consequences of a rule like this, I know the court has expressed concern about windfall to defendants, but of course that doesn't apply to all defendants. And so a judge-created rule or a court-created rule that would seek to eliminate that windfall would have to create one rule for defendants whose end date, whose sunset date has been extended and therefore haven't received a windfall and instead have had conditions imposed or reimposed that would go beyond the date of their original expiration, and then a different rule for defendants like Mr. Castellano who were subject to a life term. That seems impracticable and unworkable. Third, I would point to this court's decisions in Ellis and Holloman. If, Your Honor, Judge Heitens, if this is a rule that has its roots in forfeiture or something like that, then it doesn't make any sense that the first final judgment imposing the new condition wouldn't be the one that had to be immediately appealed. The magic that's being done by the original judgment here shouldn't matter if this rule is really rooted in forfeiture, waiver, or something like that. And yet in Ellis, we have a reimposed condition that was challenged and reviewed for abuse of discretion, even though at the oral argument in that case, there was an extended discussion about what the level of review should be. Ellis is a binding precedential decision of this court. And Holloman, the same thing. I mean, Holloman at least cites Johnson in a footnote and says, we're not going to apply the procedural bar from Holloman, and that condition had been imposed at a previous imposition. And so again, the fact that the government doesn't really have a strong doctrinal tie here, I think it would be overreading the government's argument to say, well, we're just going to call it waiver because this court has repeatedly said it's not a waiver, it's not a forfeiture thing. Otherwise, those decisions would have come out the other way. Judge Diaz, with respect to the questions about whether a change in legal circumstances here would entitle Mr. Castellano to review or relief under a McLeod-like standard, I think it absolutely would. My friend cited the Morris decision. That's at 37 F 4th 971. And that the court in that case was dealing with internet use conditions, but the same principle applies. And the court said, we're satisfied that Packingham, Ellis, and Hamilton created a new or unforeseen or changed legal circumstances relevant to Morris's internet use conditions, and it allowed the challenge under the McLeod standard. The same is true here. Of course, in Van Donk, the court was applying 3583D. It doesn't have to apply a new statute. It just has to announce a new rule. And the individualized evidence rule is clearly a new rule. I think this case couldn't be distinguished from Morris in that respect. Your Honor, I think that means that the court has to reach the merits of these conditions, and it's worth emphasizing here, Your Honors. Van Donk said that the court was comfortable with the condition in that case, at least in part, because it wouldn't risk sending someone to prison for admiring the beauty of a Michelangelo sculpture. The nudity ban here has to do just that. And yet, the government asked for it to be imposed. These broad bans were imposed in violation of the individualized evidence requirement announced in Van Donk and reaffirmed in Ellis, and we ask that this court to strike them.
Thank you very much. Thank you both for your able arguments. We appreciate them very much. We would, as you know, typically come down and greet you. We can't do that today, but hope to do that sometime in the future, but know that we are grateful for your arguments here in this case. With that, the court will stand adjourned until tomorrow morning.